These appeals are at the instance of the state of West Bengal and arise out of two prior rounds of litigation wherein the state suffered judgments against itself. We have extensively extracted the relevant submissions made across the bar, and we have of the considered view that certain questions which arise for consideration, there are 13 in number, which we have, which we'll read. What is the scope and extent of the power under Article 309 of the Constitution of India? What is the scope and extent of the rules framed by the apparent state, that is ROPA rules, and the first memorandum dated 23rd of February 2009? Whether the notifications official memoranda issued subsequent to the clarificatory memoranda dated 23rd of February 2009, that is 9th of December 2009, 6th of April 2010, 23rd of October 2010, 12th of December 2011, 31st of December 2012, 16th of December 2013, 9th of January 2015, and 14th of December 2015, issued by the apparent state revising the rates of DA are in consonance with the ROPA rules. Given that the definition of existing emoluments in ROPA is identical to the central government rules, that is legislation by incorporation, could the state have then deviated from the index being adhered to by the central government? In other words, was the incorporation of AICPI number a one-time measure? Whether DA as a concept is static or dynamic, and whether by the act of the legislation recognition of a particular index does the character thereof change? Whether the actions of the apparent state are vitiated by manifest arbitrariness, as also negatively affecting the legitimate expectation accruing in favor of the employees. Whether adoption of the AICPI would render the distinct legislative domains under List 1, Entry 70, and List 2, Entry 41 OSHO. What is the impact of the direction of the tribunal for the state to follow the AICPI insofar as the financial autonomy of the state is concerned in the federal structure of the country? What is the effect of the findings returned by the High Court in its first round of litigation? Do the respondent employees have any right to receive DA twice a year in line with the pattern of the central government? Is financial capacity of the state a ground available to deny the payment of DA if under the existing rules the same is held to be a legal right? Since the question involved in this list is the payment of DA, which is an aspect of fiscal policy of the state, what is the extent of judicial review which is permissible? Can DA be said to be a fundamental right under Article 21 of the Constitution of India as held by the High Court? The claim of the respondents is for a period 2008-2019. However, the legal redress of the alleged grievance was only initiated in 2016. Was the claim of the respondent affected by delay and latches as such liable to be dismissed? Now, these are the questions which in our considered view, which arose for consideration before this court. And we have answered one by one. We'll just briefly, we understand it's morning and we also have to go to the courts, but we'll tell you. We have said that Article 309, we have extensively discussed, and the principles enunciated are non-exhaustive. One. Questions number 2 and 3, we have come to the conclusion that in some it is thereby concluded that DA by its very nature is non-static, fluid, and subject to change. How that change is to be carried out is through the AICPI. The first memorandum is also the subsequent memoranda fall prey to the fatal flaw that they do not make reference to the AICPI, which is absolutely essential to the determination of the DA, which in turn is indispensable to the computation of the total amount of existing emoluments. As a necessary follow-up thereto, it would be observed that the incorporation of the AICPI cannot be termed as a one-time measure, and once DA was defined using it, to take a different path would be impermissible in law. So questions 2, 3, 4 are answered accordingly. Now, insofar as question 5 is concerned, it has got two facets as we read. One is with regard to the arbitrariness on the part of the state, and the second is with the legitimate expectation of the employees. And all these, on both these issues, we have said that keeping with the judgments referred to above, the principle of manifest arbitrariness under Article 14 refers to legislation that is capricious, irrational, lacking reason principle, or excessive and disproportionate. Such arbitrariness vitiates both subordinate and plenary legislation alike. In the present fact, since the legislative exercise did incorporate AICPI into the framework, deviation therefore from without any basis or discussed above falls in the lacking of reasoned principle prone to manifest arbitrariness.
passed from legislative competence. For the apparent state to have deviated from the recognized position to something else without laying the groundwork therefore compromises the exercise of rendering it capricious. So that is what we have heard. Insofar as manifest arbitrariness is concerned, we have further elaborated, and we have held that it is not so in view of Hakam Chand Supra, which you had referred to. And insofar as legitimate expectation is concerned, we have said that, of course, it cannot be unless it is by rule of law. And we are of the view that in the light of the principles referred to above, the legitimate expectation on the part of the respondents did arise in view of the change in the position of law. Otherwise, there is no legitimate expectation. Enactment of ROPA and its recognition of AICPI as the determining factor for the computation of DA. Now, questions number 6 and 7, whether there is any conflict in between the list 1 and list 2 of the schedule. We are of the view that this question does not arise in our considered view at all, and therefore we have said that there is no conflict. These both are coextensive and working in the totally different planes. Then the next question we have said is that the alleged conflict in our considered view is a figment of the imagination of the apparent state. The argument seems to have been conjured up in thin air. Where is the exercise of the power of the union, legislative and executive imposing any conditions of the apparent state? On the contrary, the power exercised is only by the apparent state through the governor, permissible under the constitutional scheme in terms of Article 309 of the Constitution of India. Now, coming to the effect of the finding of the first round of litigation, we have said that yes, it has conferred a right on the employees. Whether the respondents were entitled to DA twice a year. Here we are in agreement with the submissions made by the appellants that DA cannot be given twice a year. So to this the appeals are allowed. Now, fiscal policy and judicial review. We have elaborately discussed that once there's a right which is conferred upon a person, then fiscal policy cannot be come in the way of the disbursement of such rights. Now, whether dearness allowance is a fundamental right. We have said that in terms of the impugned, because it was not given up really, in terms of the impugned judgment, the High Court held the payment of DA was a facet of Article 21 of the Constitution of India. Before this court, however, the opposing parties have jointly agreed that none will press this question either way. That being the accepted position, we do not give any finding thereupon and leave the question open to be decided in an appropriate case. So the appeal is allowed to that extent also. Now, whether there is delay in latches, we are of the view that the employees have been relentlessly pursuing the matter before different fora. So therefore, their legitimate claim, which is recurring in nature, giving a fresh cause of action every moment, cannot be said to have been delayed, cannot be denied on account of delay in latches. Now, the directions part we have read is this. Apropos to the above, we pass the following order. The appeals are partly allowed on two issues. To receive dearness allowance, page 128. To receive dearness allowance is a legally enforceable right that has accrued in favor of the respondent employees of the state of West Bengal. Given its incorporation in ROPA rules, the AICPI is the standard to be followed by the appellant state of West Bengal for determining of existing emoluments. The employees of the appellant state shall be entitled to receive the arrears in accordance with this judgment for them from the 2008 till 2019. On 16th of May, we had passed following interim order. We have extracted that interim order where we had said that some amount be immediately dispersed. The interim directions issued are herein shall be complied with immediately. On account of subsequent change in law, if any amount that would be dispersed in compliance of the judgment shall not be liable to be recovered. Considering the financial implications involved and also recognizing the need for structured release of the funds so as to not prejudicially impact state's exchequer, while at the same time balancing the rights of the employees to receive the emoluments due to them, we find it fit to constitute a committee to monitor the implementation of the directions herein above as follows. We have requested Honorable Ms. Justice Indu Malhotra, a former judge of this court. We have also requested Mr. Trilok Singh Chauhan, former Chief Justice of Jharkhand. We have also requested Mr. Gautam
Bhaduri, also a judge of retired judge of Chhattisgarh, and along with them, the Comptroller and Auditor General of India, or a senior most officer in his establishment nominated by him. The import of the committee shall be in consultation with the state authority to determine the total amount to be paid, schedule of payments within which the state shall be bound to follow, periodically verify the release of these amounts. The exercise to determine A and B shall be carried out before 6th of March 2026. The next consequential step, that is the payment of first installment, subject to the determination of the committee, would be paid before 31st of March 2016. The committee shall be accorded all facilities and privileges, including all necessary logistical arrangements. Expenses shall be borne by the applicant state. Insofar as the remuneration is for the committee members is concerned, we leave it to the wisdom of the chairperson. It stands clarified that those employees of the state who have retired in dependency of this litigation shall also be entitled to benefits in accordance with law. Let the appellant state, after payment of first installment, file a status report indicating the determination made by the committee, the schedule adopted, the status of the first payment, list on 15 May for compliance. These pending applications also stands.
Grateful. Very good.
My lords, the employees are extremely grateful.
We'll only say we have rendered justice, that's all. Right or wrong, good or bad, we don't know.
Actually,
chairperson लिखा है ना
grateful.
Thank you,
Very.
But for you, we would have been able to, and my lord's contribution, largely.
Your lordships have burned the midnight oil. We have only worked around 10 p.m. or 11. Your lordships.
No, you have also burned midnight.
You don't know how much my lord
effort we
had to,
we appreciate, my lord. Grateful. Very good. Very good.
Thank you.
case.
Item 1501.
For the reasons recorded herein above, we are of the considered view that the impugned judgment is reasoned and borne out from the material on record, except to the limited extent expressly modified therein. This court does not find any ground to take a different view from that taken by the High Court. Accordingly, the civil appeals are dismissed.
Thank you.
Item 1.
These are before your lordship begins the bench. These are that British motor case. That 104 is wrong. They said yesterday lordship adjourned it to 17.
We realize that it has to.
The lordship may direct the registry to.
We'll do that. I think the order needs to be corrected.
Yes, because it has gone to 17 because lordship is sitting in the combination.
Order needs to be. Today it is listed, na?
104 it is this.
Ma'am, just wait. Just kindly wait.
I'm in your lordship then. I just
no,
want
we'll
to
do that.
your lordship notice.
We'll do that. What we are saying is that the item comes.
Yes, we'll do
You
that.
are here only.
Yes, my lord.
You are one of those
It is a pleasure.
who never leaves the campus of the Supreme Court. just.
It is a pleasure, my lord.
Your affidavit have you filed?
Yes, my lord.
Affidavit.
Second of February, my lord.
We are,
Very short affidavit I have
we
filed.
give, my lords, we undertake to, my lords, provide the requisite undertaking before the jail superintendent.
But,
In terms of the affidavit.
but I fail to understand why a 32 and why a writ petition.
No, my lords, because there are multiple FIRs.
It's okay.
in
You have
different cases.
been granted bail in number of cases.
My lords, otherwise, my lords,
Otherwise, this will become a trend that file a 32 petition and get bail.
my lords, in this matter, my lords, because I would have been required because of the medical condition.
No, you
for the
recently.
emergency.
I was going through this order 212024. You have been granted bail in one case.
That's right, your lordships. But in this case, my
No,
lords,
so
I
why
would
to
have been-
bypass that remedy? Then it will become a trend. Everybody will file a writ petition, get a bail, and then if that petition is dismissed, come to this court
My lords, we went in 226 only for this reason.
for bail.
But,
For bail.
my lords, we went, my lords, only for this reason that at 4 different places, I would have been required.
How many FIRs are there against you?
My lords, total, my lords, cases in which, my lords, I am in custody. Total FIRs are 21, in which 9 I have been acquitted. 12 are the pending cases.
And in 12, how many cases you have?
8 bails I have already got.
So how many are left?
Only, my lords, 4 matters.
4.
I
So
am
you
in
can,
custody.
if the court has granted you bail in 8 cases, 4 again the court will grant you if there's no material.
My lords, I will be required to, my lords, go to Chittorgarh, my lords, Bali, Jaipur, and my lords, one more place.
The interim bail is for how long? For what period?
My lords, we are requesting a lordship for 3 months.
3 months medical treatment, 3 months.
Lords, because I am the only, my lords, parent available.
One minute. According to you, what is that you said?
Lord, if your lordship will have this affidavit dated 2nd of February, my lord. 2nd of February,
Yes.
very short affidavit on behalf
No,
of the state.
where you have said that he will furnish the details of the hospital where his wife will undergo treatment surgery.
Age
Uh,
3 months.
So what is the period which you have suggested here?
Period, any reasonable period, whatever you have said. On period, I have not said anything.
Maximum surgery will take how much time?
My lords, surgery will not, my lords, it's a post surgery, my lords, recovery will take, my lords, about 2 months.
No, what we'll do is we'll give you 4 weeks time for this. And should there be, depending upon the further requirement, then you move an application.
My lords may have it for 45 days, my lords, for the reason that I am the only parent, my lords. My parents are not alive, my wife's parents are not alive. There is nobody in the family.
We have perused the affidavit filed by the
45 days.
We have perused the affidavit filed by the state. In principle, state has no objection to the grant of interim bail.
It'll be on medical and humanitarian.
In principle,
Yes, ma'am.
for the reason that petitioner's wife has to undergo surgery,
And there is an 11-year-old child, you know.
and there is none else in the family of the petitioner to attend to her. More so when there is a 11-year-old child born through the wedlock. In these attending facts and circumstances, we allow the application in the following terms. A, the terms and the conditions set out by the terms and the conditions as the state has referred to in para 5 of the affidavit shall be strictly adhered to. The interim bail, the period for interim bail shall be for 45 days from the date of release. The petitioner, during this, we clarify that the protection is granted, that the liberty is granted only for the purposes of the treatment of treatment of the petitioner's wife, who has to undergo surgery on account of personal ailment. Then, after the expiry of 45 days from the date of release, the petitioner shall immediately surrender.
And my lords, conditions be subject to the satisfaction of the jail superintendent.
The condition shall be, no, petitioner shall produce with the concerned magistrate.
Consent budget.
Magistrate
All.
for
Then my lords, it will require 4 different men. That's why my lords, I was jail superintendent earlier also, my lords.
Lord, he can file the undertaking before this honorable court to fulfill these conditions, my lord.
no. Conditions of the jail superintendent.
I am going to comply with all the conditions and I will give my undertaking in terms of the conditions given in
Jail
here.
superintendent, and petitioner shall file an undertaking before this court to the effect that he shall comply with the terms and conditions part of the order.
As a lord.
Very good.
Please, sir. Item number 2, I appear for the petitioner. Lords, in this matter, service is complete on the whole respondent, but as per the office report, no one has entered appearance. Lords, in this matter, I was non-suited on the ground that under the Chhattisgarh Commodification Act, my husband doesn't count as a spouse under the definition of member of the family. So the case against me is that I have created a subtenancy in favor of my husband. But husband is a protected member, my lords. He's the spouse under the definition of member of the family. And on the second count of bona fide requirement, the plaintiff already has 2 other shops in Mahalakshmi market in the same area. And one shop he has already sought eviction against.
Subletting, you may be right, because the definition of 2B includes spouse.
Yes.
But as far as the bona fide requirement is concerned, you see.
It's his choice.
Milords, but I have a certain protection under the Act from eviction.
You take time to okay. How much
You are
time?
there for the last 21 years.
Please,
It's
my lord.
not your property.
Please, Milords.
Please leave it.
Milords, then in
Please
that
vacate it. No, no,
6 months' time may be granted. I'll evict.
Six.
All
close my
right.
business.
Fair enough.
Undertaking.
Please. Grateful. Thank you.
Item 3.
Your good name, please?
Advocate Namrata Chandorkar.
Namrita.
Yes, sir.
We are from my state.
Yes,
My
sir.
undivided state.
Yes, sir.
The lot belongs to the entire country, my lord.
No, but see, all fingers are not equal.
No.
Bias towards.
1 minute. Now, my lord now has to give relief to him.
Why is it Madhya Pradesh?
Unfortunately, my lords, the stage of granting relief today will not come because the state is taking some time to come back with a bit.
No.
So,
Let us see first.
They filed an affidavit.
very good. So my learned friend just told us that, my lords,
There was
they are withdrawing their affidavit.
No.
That's fine. Very
Didn't
good.
say that. I'm not
Very well.
going.
Better for us.
Your Lordship had asked certain queries on the last date, Your Lordship, and I had given a affidavit in this regard.
Maybe I'm taking time.
So the number which has come up, Your Lordship would have page 3, paragraph 4, where I have just given the list of the query which was raised on that day.
This is which one? Which affidavit?
We
3-2.
have filed
3-2.
yes,
Yes.
affidavit on the this is the 1359 SLP Civil 1359 of 2023.
There are how many vacancies?
Yes, Your Lordship. Now, if Your Lordship would have paragraph 6, that the total vacancy of 7129 posts and the category wise detail was given in paragraph 7, paragraph 6. Then in paragraph 7, it is stated that there was total vacancy of 3546 posts of home guard and the category wise detail is as follows. Then in paragraph 8, it is said that out of the vacancy of 3546, the total vacancy seat filled for all category of home guard is 297. Total women seat filled with home guard is 6. Total women seat unfilled for home guard is 116.
Hardly 300 people.
Yes. These are the seat, but Your Lordship, here what the case before you, Your Lordship, is that they are not having requisite qualification.
No, I was not able to find anywhere. This statement of yours is not in the main judgment. The issue was filling up of the vacancies which could not be which were not filled because of want of home guard candidates to be given to them. That was the issue.
Your Lordship, the finding also says that the minimum requisite mark, the cutoff mark was 169.
No.
I'll show that. The cutoff marks was 169. The marks of
Please show it from the judgment.
Please, Your Lordship. Wo judgment ka lo.
I could not find that line.
Absolutely right. The question is about minimum eligibility, which all of us clear.
Your Lordship.
No, now that my learned friend is going ahead, allow me to address it. Now, my lords, what had happened was this, and the infirmity in the order.
May I just complete, Your Lordship?
No, I am addressing the court.
We followed your cutoff issue.
Okay.
Because insofar as the minimum eligibility is concerned, every candidate which is before the Supreme Court has minimum eligibility. Those people who do not have, I'm giving it as a caveat, those people who do not have minimum eligibility are not entitled to come in. I'm not claiming for them, first of all. That's the fair submission that I'm making. Second thing is this, that the High Court has messed up, my lords, by confusing the cutoff with the minimum eligibility. Now, cutoff, my lords, is a dynamic concept. If there are 50 seats only, there are 500 people, the top 50 candidates, the lordships are right. Now, my lords, therefore it keeps moving. There were more vacancies. So if the vacancies are increased, the cutoff is bound to fall, point number one. The vacancies in this case exist. The rules say that if there are vacancies in the home guards and in the women reservation, they will have to be filled up in that year.
That is the law. That is what the rules are saying.
No, that is not.
Their own counter affidavit at this point.
Only, no.
So the.
He's right. Only in respect of women, the carry forward process will be applied.
Your Lordship.
Only for women.
Now,
Just complete your Lordship.
therefore, when it comes, your Lordship's right.
Horizontal one.
That is so. Therefore, because of the application of the law laid down by this honourable court, and we are carrying all of those.
How many candidates are there?
Well, it's
Oh,
320 or something.
Here-
The vacancies are all there.
And just
And there is a stay
one
on
submission,
future.
your
There
Lordship.
is a, my learned friend will just bear with me. There is a future stay of future recruitment also by this honourable court. All of us can be adjusted this.
This 2025 recruitment.
Please follow.
May I just complete.
I'm grateful.
My submission, your Lordship. You may
2024.
start thereafter.
2024.
2024.
Your Lordship would have by counter in SLP
That's why I
3950.
request my learned friend to just hold his horses for 2 minutes, my lords. I'll just place the facts and after that he can have the court's attention. My lords, that process has been stayed. There are vacancies arising from the 2015 advertisement under which we are claiming. This is the affidavit pertaining to that. The last order passed by this honourable court requiring the state to come forward and to give details was only under the advertisement of 2015. So what my learned friend has pointed out in paragraph 7 are the number of vacancies which are available under that advertisement, and they are now being adjusted here. We are candidates who, my lords, have promptly gone to court, have been agitating this by a wrong interpretation of the rules, and from their own counter affidavit, the rules filed by them, we can, my lords, make an attempt to satisfy your lordships, my lords, that the rule position is very clear. Home guard vacancies which are unfilled have to be filled up, number one. Number two, insofar as the women reservation is concerned, the law by this honourable court is very clear. They will not be followed, carried forward. You have to adjust them on this. So we're carrying all of that. So, my lords, today, my lords, once they have shown that there are so many vacancies, without going into anything, my lords, all of us can be adjusted, and I am only asking for an adjustment.
They're your young boy,
May I just say, your Lordship.
They are young boys from
Your
the
Lordship,
state. Most of them have become
If
over.
if I may be just permitted to make two submissions, your Lordship. The first thing, your Lordship, as I'm asked by the
Your Lordship, if I may-
council for the selection commission, your Lordship. Out of these vacancies, your Lordship, there were several which have been already filled by the operation of the advertisement of that year only itself, your Lordship. So, your Lordship, their data also need to be incorporated into
Then
this.
why you give this affidavit?
When I said, my lords, not the affidavit, my learned friend just
Then
told
why
me
you
now.
have given this?
After argument, he's coming with this now, my lords.
Your Lordship, and the second thing, your Lordship, is your Lordship would have my counter affidavit, which is in the Mahatab Khan case, 3950.
It is not with him, then he's.
File a fresh affidavit.
Okay,
My
Lord.
lords,
But your
it will be
Lordship,
unfair of my learned
let's
friend.
have a.
Initially, he told me that he is taking time because he wants to change the affidavit. Now, my lords, seeing
He,
with the bill
might
and blow.
he might be under the impression that the second new
Yes.
judge is there. So let me take a chance.
No, your Lordship.
I couldn't have said it with greater clarity, my lords. That is all.
No, but see.
The cat
they
is
have-
out of the bag.
They have passed preliminary examination. They have passed written
Yes,
examination.
yes.
They have cleared the interview. They are physically fit.
Document
medically
verification.
Fit.
Yes.
Document verification. You do have vacancies. You do have large number of vacancies. And most of them by now are over.
Correct, that's correct.
If I may only.
No. Either you argue, we
she's
decided. If you want time to file a better affidavit.
Okay, we'll file it,
No, there's only one thing I wanted to point out.
No, sir. We'll,
May I just,
1 minute.
yes. Your Lordships are not passing in the office today, I know.
1 minute, 1 minute. On the last two hearings, last hearing, precisely what has fallen from a law, we have said that. That is why we asked for this information. So you better file a better.
I'll do that, your Lordship.
Simple as that.
I'll do that.
And let it be a win-win situation for all.
Okay, Lordship.
That's all. My lords. The court is.
Only thing we have to see is inter-see seniority between them and them. That's about all. That will
That my lords can decide. That's okay.
Lord, I'm not part of this, but Lord, I have filed an application for
Then-
it. There is a reason. We are home guards. Our non-selection is under challenge. Your Lordship's court, my Lord, has issued notice in our SL.
let us.
Lord, any filling of the post under the directions in this manner.
They have not passed their
Our
minutes.
selection.
They haven't passed it.
Therefore, I wanted to bring that.
1 minute.
how many home guards are there?
Lord, we are in all in our petition about 200 home guards.
So the vacancies are 2,000. 2,000.
There is scope for everyone.
2,000.
It is pending in court number.
Sir, 1 minute. You want us to send it there?
No, I
problem.
don't say that.
Then
We are home guards.
we are saying we'll make a win-win situation for everyone.
Very well, Lord.
We'll make sure that you're also accommodated without a judgment from that court. When we are saying that,
Don't worry.
Not
We'll-
this
we'll-
Vande Bharat Express has got too many coaches. Everybody can be found.
दिखेगा.
One clarification must come on record.
Thank you.
I'm only requesting, Lord.
Thank you.
That you can only file an
You have
affidavit.
to mention before Honorable the CJI for listing of any man.
No, I'm not mentioning anything, Lordship. I'm on party here, Lordship. In this,
Then it's all right, then we'll consider.
I'm only saying, Lordship, that the affidavit is with respect to only vacancies, not that the horizontal reservation cannot be filled up. That's a
Seeks permission to
The
withdraw,
affidavit should be confined to vacancies.
withdraw the present affidavit dated so and so. Present affidavit so and so. Affidavit dated so and so, filed on behalf of so and so, with the further liberty to file a fresh affidavit
3 weeks, Your Lordship. 3 weeks, Your Lordship.
containing
Notes.
better particulars within a period of 1 week.
My lords, I have not even till now heard what those purported better particulars are. My learned friend says better affidavit, but what better affidavit he wants to say is not something that any one of us are aware
Better
of.
affidavit within 1 week, list on dash.
1 week, Your Lordship, will be difficult, Your Lordship. 3 weeks, Your Lordship. 2 weeks.
Data is with them, Manoj. We've gone through everything, they filed an affidavit, at best a correction.
Thank you.
We can say. I'm grateful to your Lordship and also to Justice Sharma for putting to my learned friend what I couldn't have said to him. So, that's very good. Deeply obliged.
You were there in that Bihar matter?
Yes, sir. That's
So you know the trend.
We've been here enough to see that. So, very grateful. Manoj. Deeply
Grateful, my lord. Much obliged.
Grateful.
May I please? So all the affidavits on record, my lords. Lordship's query whether the regulation is applicable, whether Praneet case is applicable, whether are we receiving any amount from UGC, my lords. Because the affidavit says, my lords, up to 2018 we received grants. Thereafter, no grant from UGC by the university. Only with regard to, my lords, women's development, only we have received fund, my lords.
But you have received funds.
No,
Yes,
and your affidavit, with due respect, is a mischievous affidavit. Where is the affidavit? Please give it to me. I'll point it out. It's a mischievous affidavit. Please come to your affidavit.
My lords.
Where you have said about that grant.
It's para 3.
पूरा file दे दीजिए ना आपने.
No, this is not the affidavit. एक दूसरा affidavit file किया है. In petitioner का affidavit. This is an application for an impediment. कल रात में मैंने देखा था.
Filed on 24.
Filed on?
24/1 minutes.
I've seen it yesterday.
Para 3 minutes.
Come to Parath. So
Well,
what you are saying in this?
it respectfully submitted that the petitioner is receiving salary grants from Government of Tamil Nadu. University Grants Commission is not offering any salary for the faculties appointed in the petition universities. UGC schemes 10, 11 and 12 plans are implemented and faculties are appointed in the plan period. At present, 12 plan, Women's Studies Center is alone receiving the grant. Till 2000.
What is this UGC scheme 10, 11 and 12 plans?
These are the plans
What is
for
that?
development of Melod's travel grant, conference, public grants, appointment of visiting facilities, daycare, adventure sports. That's a heading, Melod's, for each and every.
That's a heading. I'll tell you what it is.
Melod's.
When a plan is sanctioned, 50 posts, 10 posts, 20 posts comes with the plan.
Please,
And in no university, once the plan is sanctioned by UGC, is discontinued.
Melod's.
So this you are receiving grant for number of teachers under the 10th plan, 11th plan and 12th plan. So just to misguide us, you have simply written UGC schemes are implemented. You have not said that you are receiving financial assistance for paying salary to the teachers under these plans.
No.
So that is why I said it's a mischievous affidavit. You are 100% receiving grant for large number of teachers from the UGC and for Women's Studies Center where teachers are employed.
Melod's.
No.
Distance. I'm so grateful.
I have filed an ID in the matter.
We are not impeding anyone.
Observation to that effect that lordship we can on the basis of order we can.
We are not saying anything, ma'am. So grateful.
Grateful.
Manoj, I'm requesting for a pass over and anthem of 5.
Pass over.
What?
Please, my lords. Look, this is that matter your lordship said twice sent for mediation, my lords, between the husband and wife.
Waiting for a past tense. Okay. It's possible.
Please, my lords.
My lord, only last night I have received the counter affidavit and I need to file the.
Let's see what the matter is.
It is about the additional charge, my lord.
Ah,
And certain deposition has been filed in the counter affidavit, and there are so many contradiction in that. And I need to file.
no, additional charge, see, counter we'll ignore. But additional charge, section 333 allows, so what is there in it?
No, that is, my lord, after
What is
presenting the
charge?
final argument,
Huh?
after presenting the final argument by both the parties.
Your 482 has not been allowed.
Yes, the police inspector with the deceased.
Yeah,
Has been assaulted.
Yes, yes.
Please, my lords.
My lords, I didn't understand.
Dismiss.
My lords, no. My lords, I have a substantial.
Then argue now. Yeah, that's what we.
Kindly pass over the matter. I will bring my file and I will argue the matter.
No problem. No problem.
Sure.
Come immediately because.
But my lord, the problem is that they have filed particular deposition.
Ignore that.
Sure.
You argue your case, please.
We are making it clear, come immediately, bench is available only for a limited period. Huh?
My lords.
And if you don't come by 12 o'clock, we are.
Dismissed.
Dismissed.
Lords, the state was the counter, my lords.
Which case?
Item 7.
No, settlement was there.
Said, my lords, we've filed the SLP praying that there should be a appointment from this court.
Had we not requested for just 1 minute? No, sorry. Yes, argue.
My lords, the state had to file counter, my lords. It's not on record.
My lords, I appear for the state. My lords, it's a concurrent conviction. My lords may hear the matter and call for the records. There is a long list of evidence that has not been filed with the SLP, my lords.
No.
My lords, it's a matter of conviction under 420, my lords. There are over 5,000 members who were made to pay.
1 minute. Now, conviction is there, and suppose if you were to pay the money back.
My lords, it's 420. So, with my lord's permission, it can be. But we'll have to trace the complainants and all the members, my lord.
Lordships refer it to the mediation, my lords. The president will file an affidavit and the association.
You have taken money and you have not given plots. Give their money back.
My lords, I was 22 years, my lords, at that age. 2001 was the date of FIR. I was 22 years, my lords. Today I have come, my lords, only out of all 60,000 members, only 105 complainants are there. Even they have filed civil suits, they are in their respective position. They need something, I am ready to pay. So, my lords,
you're not doing charity. You have to return their money.
My lords, we will do that, my lords. That is the petition. That is why I have filed.
Otherwise, go to jail.
I have filed the petition for that.
No, but will you pay? That's the point.
My lords, I left it to the court, my lords, that somebody should be appointed so that they can put their claims there.
Do one thing. What is the total amount involved?
My lords, they are about 105.
Total amount involved.
My lords, they have to put forth their claim, my lords. We cannot.
They are only asking you what is the money involved which you have taken from them.
It's the amount.
You deposit in this court.
The president would be the best person to say, my lords, the association's president. We'll do that, my lords. The association president, my lords, if it's referred to mediation, he will come and file appropriate act.
These suits have been filed for what amount is what we are asking.
Suits they have filed for injunction, my lords. It's an injunction suit, my lords. It's at page 24, my lords.
You do one thing, we'll just pass it over. You ask your clients how much money he is ready and willing. You see, he is conscious of the fact they have been convicted by the trial court, acquitted by the first separate court, and then again convicted by the High Court.
Yes.
And 2 years is what the High Court has asked you to serve.
Yes.
Imprisonment. But what is the very important is, should you wish to settle, to test your bona fide, deposit money in this court. What is that money which you will deposit here is what we are asking before we even ask them.
My lords, may I submit, my lords? I also have surplus land. If title deeds of the land can also be deposited. Surplus land is there. Money.
First,
I'll just
go
find.
out and
I'll
find
do.
out how much of money
I'll.
and how much of land
I'll.
you are ready to.
I'll. I'll.
My lords, as per the charge sheet and even the facts recorded in the trial court, my lords, for the year, because this is almost a 30-year-old incident, and the transactions were in 93 to 95, my lords. My lords, at that time, the charge sheet records an amount of 5,35,000 only, my lords. So, however, my lords, this is as per what is on record, but my learned friend may clarify that. And it's also keeping in mind 30 years have gone by since.
Exactly. See, so 30 years, what would be the rate today is what he has to deposit. Simple.
Yes, my lords.
Go out and immediately just
Pay back matter and
Grateful, ma'am.
And of course, this will be subject to the other side agreeing. We really don't know whether they want to pursue.
I won't.
But suits are pending, they'll all come to an end.
Please, Your Lordship. Yes, 2811, the Honorable Court made an interim order, a speaking interim order. I request to have a look at my Lord's order of 2811. Para 3 thereof is a request to consider. If I could place it for Your Lordship's kind consideration. Honorable Court said, inviting attention to the prayer clause C of the plaint, page so and so, it is argued that the amendment sought to be brought in, as is evident from the application page so and so, para so and so, was not for the purpose of changing the nature or character of the suit. It was very clarificatory in nature.
Let's see page 71 and 287.
Yes, my lords. Because please have a look at page 84, my lords, want to see, my lords?
Yes.
84, lordship, have a look at. This is a part of the plaint, my lords, the prayer C, 84.
83.
Yes, I'll read from 83. My lords. 84 is the prayer C, but I'll read 83 also.
Anyhow, it's all right. That the plaintiff is entitled to get possession of the land.
Yes.
And
the prayer is made, my lords, actually made.
Correct.
No, my lords, then kindly see the application 266. The application is 294, I'm sorry. Where I sought amendment, 294.
What is the amendment? Page 294 that the plaintiff.
Yes, at 295, bottom of 295, just at the top, second line, the plaintiffs are entitled to obtain possession by partition of suits. So only clarificatory in nature. Prayer was already in the suit, my lords. The first appellate court holds in my favor in entirety, but on this ground, kindly see 266, because of which I made the application. 266 is judgment of the first appellate court. 266 para 31 is the request to consider. The appellant plaintiff also, I am for the plaintiff, has a share in the disputed land along with defendant so and so, but he has not asked for any assistance in partition in the claim. Therefore, this court cannot give any assistance to the appellant in getting possession of the land as per his right and share.
What is that the High Court?
But the court says kindly see at 267, 33, on the basis of the above findings, the appeal is partially, the first appellate court. The appeal is partially accepted and the judgment of decree of so and so is set aside. Following decree is ordered that the order of so and so is illegal, set aside, not binding on the appellant, etc. So no order for possession. So, the High Court in this application.
High Court says it will change the nature.
Yes. That's the only, my lords.
My lords, allow me 2 minutes time and to show you 3 documents. It is my humble submission that they are arguing a settled position. Their amendment application does not clarify. It seeks to change the nature of the suit.
How?
Yes. Three documents. First, my lords, let's look at their amendment application, page number 294, 295. Page number 294, paragraph number 5, the third last line. My lords, by way of amendment, they want to now argue at the High Court stage that fourth last line from the bottom, my lords, page number 294, that the suit property is ancestral property
in which both daughters and the son of deceased Sukya each have 1/3 share. So their first amendment is that this property is not self-acquired, it is ancestral. Just on this point, there are concurrent findings of both the trial court, the first court and the second court. Findings. My lords may kindly have page number 149 just on this point. My lords may kindly have 149 of their petition. My lords, page number 149. I'm reading from the last 2 lines of page number 148, my lords. This fact is admitted by the plaintiffs themselves in their cross-examination. Not only this, Mishri Bai, my lords, she was a plaintiff there, she's a petitioner here. Mishri Bai herself has admitted in her cross-examination statement that the disputed land is not the acquired agricultural land of Sukya. That is the father. It is also admitted that the suit property has been purchased by Sukya from his hard-earned money. Her father was a hard-working person. In this situation, it is very clear that Mishri Bai has admitted the fact in a cross-examination.
We must correct you on one point. Are we to look into the evidence which has been laid for considering the application? 1 minute. All that we have to see is the plaint and the application where it changes the nature and character. Now kindly come to his plaint, page 78, paragraph 2. Here he says, the heirs of Sukya, father of Kallu, includes son so and so. The Amrit died on so and so, before so and so, older Sukya, due to which the heirs of deceased are not defendant so and so. So all that he is praying is that the Sukya's property be partitioned. That's all.
Very well, my lord.
Therefore, he has set up it's not a new.
My lords, on page number 78 itself, the title of the suit was Declaration, Possession and Entry Name in the Revenue Records. The valuation of the suit was as per declaration. It was not for partition. In Madhya Pradesh, my lords, may just allow me 2 minutes.
Are we to look into all this at this point in time, whether the suit is undervalued or not? All that we have to see.
My lords, there are 2 important things that they did not argue for 18 years. The first is partition. There are 2 sisters. How are we to know? My lords, they have simply, by a simpliciter way, said 1/3 share, please include it in our amendment application. Now, my lords, the High Court at this stage cannot go into evidence to see how much share belongs to who. There are 2 sisters. That is something the trial court has to do.
So therefore, the High Court will, all that the High Court has considered, or for that matter, we have to consider whether the application is belated, is necessitated.
But my lord, how can the High Court at the second appeal stage see what is the share of every person in this case? For that, the partition suit has to be filed. 1/3 share is something that they're claiming here in the Supreme Court and in the amendment application before the High Court 18 years after the trial has already begun. Lord's judgment, if I may just cite my lord, my lord's judgment of 2024, my lords, Dinesh Goyal versus Suman Agrawal. It is my lord's judgment in which my lord has. My lords may kindly see paragraph 11 of my lord's judgment.
Judgment is of the court, not my lord.
My lords, the same bench. Now, my lords, in this case, my lords had very well looked into what is the rule and the settled proposition on amendment, right? And my lords had also cited, my lords, the earlier case, which is Life Insurance Corporation. Now, if the facts of the case are completely changed, in this case, acquired property versus ancestral property and 1/3 share. These are 2 specific allegations, my lord, that requires evidence to be laid.
We again put it to you.
Ji.
Whether the amendment is to be allowed, whether it can be allowed at the stage of second appeal or not, is all that we have to examine. Whether it nature changes, is there any bar that the amendment cannot be allowed at any stage of the... No.
My lords, my only request was, this is the Article 136 SLP that they have filed, and there is no reason, no substantive right that is extinguished. The High Court is still going to look into the merits. My lords, let the High Court decide on the merits. If they still have a grievance, their remedies are not exhausted. So why indulge them for procedure at this stage, my lord? That is my only humble submission.
So whether the further evidence is required or not is for the High Court to consider.
But my lords, the High Court cannot be asked to look into, and which is why the High Court rejected it. My lords, we just have page number 3 and petition, my lord.
And counsel to the party, we have to consider you that
My lord, just one last line, my lord. My lords may kindly look at one line of the High Court order, page number 3. Page number 3 of the petition. My lords, the first paragraph, last line. The High Court says specifically, my lords, that the proposed amendment would
invariably change the nature and correct
for partition and separate possession. So I am saying this requires dismissal at the threshold. That is my humble submission, my lord.
Would you allow us to know?
Yes, very well, very well. My apologies.
Chamberlain allowed him to raise the.
Please, Your Lordship. You must object, Your Lordship. I'm grateful to Your Lordships. Please.
Item 9. Yes, my lords. I beg to appear on behalf of the learned ESG, my lords. We filed our rejoinder subsequent to the last order. My lords may post it for arguments any day.
Sorry, say that again.
My lords, I beg to appear on behalf of the learned ESG. Pursuant to your last election, we filed our rejoinder. My lords may post it for arguments on any day.
No, what is there to argue?
My lords, counsel for respondent is appearing through VC.
Please, my lords, I'm there on VC. For some reason, the video is not switching on.
That's okay. We can hear.
My lords, there are serious charges of corruption and sexual harassment in this case. The respondent has been awarded the penalty of compulsory retirement. Soon after, on submission of his pension papers, the pension was reduced to 2/3 of the pension amount by the competent authority, which is the Lieutenant Governor in this case. The competent authority continues to be the same. It's a part of his responsibility and a statutory penalty which has been imposed pursuant to Rule 40.
The Rule 40, does it say that gratuity and pension is to be forfeited?
It allows reduction. It specifically allows reduction of gratuity and pension in cases where compulsory retirement has been awarded as a penalty.
My lords, once the disciplinary authority has passed the order. Yes, my lords.
You were not called upon. Please.
Very good. Which rule says that in case of compulsory retirement, pension and gratuity will be forfeited?
Will be subject to reduction, my lords.
Which rule says that will be forfeited?
Rule 40, my lords.
Where is that?
It's, my lords, it's extracted at page 3 of the impugned order. My lords may allow me to read it. Compulsory retirement pension. A government servant compulsory retirement from service as a penalty may be granted by authority competent to impose such penalty, which is the Lieutenant Governor in this case. Pension or gratuity or both at a rate of not less than 2/3 and not more than full compensation pension or gratuity or both admissible to him on the date of his compulsory retirement.
So that order should contain all this. Kindly read further. From the above, it is
abundantly clear that reduction in pension or gratuity as contemplated under the said rules is not an automatic consequence of the of compulsory retirement. My lords, this is our argument.
No. There has to be an order. You have.
My lord, that order was this matter. Once the Pay and Accounts Department considered the pension papers, it was reverted back to the Lieutenant General who, upon consideration.
No, he can't pass orders in pieces.
My lords, once the charges have been established.
It should have been part of the main order only. That keeping in your misconduct, the gravity of charges against you, the competent authority is now reducing your pension all in view of Rule 50.
I quite see that, my lords.
Then the High Court has rightly dismissed it.
There is, my lords, it's our humble submission that seems to be a bit of a technical ground. In that, my lords, once the charge.
Unfortunately, people succeed on technical grounds.
I quite see that, my lords, but once the charges have been established, my lords, the nature of the charges, sexual harassment, corruption.
You could have very well dismissed him for this.
My lords, dismissal was granted, compulsory retirement was granted.
It is not dismissal. Compulsory retirement is not dismissal, madam. You could have dismissed him from service.
What my lord is saying is that if the charges were so serious and severe, in your wisdom, rather than allowing him to step out, you should have thrown him out, which you did not do so. So therefore, as an afterthought, today you cannot say that the gratuity in pension is also to go. Thank you very much. You argued very well. What's your good name?
My lord, Harshita Chobe.
We appreciate the efforts, the submissions made. While fully appreciating the submissions made.
Yeah, Harshita was fighting with great force.
We find ourselves unable to be persuaded in allowing the presentation.
Grateful, my lord.
Grateful, my lords.
Item 10.
Executive for the petitioner minutes. As per the office report, the respondents have been served.
No, sorry.
As per the office report, the respondents have
been. What about the office report? We often say that we issue notice for various reasons.
Well, this was a matter, Lords, where I have filed a fresh suit. Prior to that, I have moved an application under Order 23 Rule 23 Rule 1 for withdrawing my counterclaim. Pursuant to that, I have filed a fresh suit seeking my share in the property. That was rejected by the learned trial court under Order 7.
Can you come to page 43?
Any liberty was granted to you?
With all due respect, Lords, the order says in terms of the application. Please have an exhibit P3 at page 43 for a while, Lords.
Your application is, where is your application?
My application is at
101.
Lords. This application was filed by, this is under Order 7 to 11. Lords, we just have the initial application filed by me for withdrawing the counterclaim.
Where is that?
Lords, please come to page 40 in exhibit P2. 40. The operative part is at page 42. If Lords permit, may I read?
While reserving the right to represent the case if a new dispute arises.
Now, please come to page 44, what the learned trial court records. This is a dispute between the brother and sister. Page 44, if my lords have that. The operative part, I read, on the basis of the application regarding the counterclaim, the application under Order 23 Rule 1 is accepted and accordingly dismissed. Therefore, it was on the basis of the application. In the application, I have specifically stated, I reserved my liberty.
No, just one. Let's read the page 43 together. The case record was perused. From the examination of the case record, it is clear that after submitting the application, defendant Mullabai did not produce any evidence. From the application submitted on behalf of the defendant Mullabai, it is clear that she did not wish to withdraw her counterclaim due to any procedural defect that may cause in failure, but rather because she does not wish to seek any relief from the plaintiff.
Is a plaintiff. For the reason why I said so, my lords may just have my application for a while.
We have seen
the application says that since because there could not be any in future, if any, since the parties were living with each other, both the brother and wife, the brother and the sister, and in order to maintain harmony between the parties.
The only difficulty which is coming this way is these 4 lines at page 44, top 4 lines. That's the only thing. Because it doesn't say simply that the application is disposed of in terms of the application is allowed in terms of the prayers made in the application.
Well, the learned trial court, with all these records on the basis of the application. So if I say on the basis of the application, that includes whatever I have stated in the application.
You are the...
I am the sister. I am the sister. And Ghasiram is my brother. My share in the property is 0.49 hectares.
0.49
hectares.
Long pending dispute, small area involved.
Therefore, I was under the impression if the respondent would have been appearing in this matter would have been sent for mediation, but he chose not to appear.
Then what do we do? Thank you very much. Thank you. We are not replying.
Lords, that was all respect, Lords. The application should rejected only when it was.
It doesn't, it's not like that.
Object.
11. May I please, Your Lordships? Lordships, I've been led by learned senior Honorable Kaushik sir, but
This input was already
before my learned will say with regard to the infectiousness, let me at least put forth what the issue is that, Lordships.
Let her say.
Lordships, the present SLP is as against the challenge of the order under 227, Your Lordships. The High Court, on 3 occasions which I had presented that this RLTOP is not maintainable, was not considered. As against that only I have come over here, Your Lordships, before the Supreme Court.
Tenant.
Your Lordships, I am not a tenant is what the dispute is. Therefore, I had filed a suit which is a proceeding wherein issues have been freed and PW1 has not come into record.
Good, claiming that you are owner by way of adverse possession.
I bow down, Your Lordships. Lordships, over here. Lordships, but that suit is pending. My humble submission is, Lordships, may I say this?
There's a person who's claiming adverse possession. There's a person who's holding clear title.
No, Your Lordships, that is what. They are not holding title. My submission is not even a single document. Your Lordship may take the rent control proceeding petition. It says that for arrears of rent. But whereas over here, Your Lordships, if assuming they should have filed it, it should be on only 21(2)(a). Your Lordship, last occasion we had circulated the act also, Your Lordships, for your kind perusal. Only under 21(2)(a) they ought to have filed. Rather than 21(2)(b), they cannot file. Your Lordships, may I say this, Your Lordships?
You simply withdraw it, saying that the
your appeal is pending.
Lordships, appeal is pending, Your Lordships, but as far as this issue is concerned, even RLTOP cannot decide on the title, Your Lordships. Lordships, on title it cannot be decided is what my humble submission.
Is this ground in appeal?
Lordship, we have raised it that...
Raised it, then please argue it.
Because the reason under 42, it is barred to look into that issue, Your Lordship. For a moment, for the provision alone, Your Lordships.
Your decibel level just low.
Your Lordships, I'm sorry. Lordships, 42 provision alone, because...
You are a tenant.
Lordships, I'm disputing it, that, Your Lordships.
But courts have held it so.
No, Your Lordships. May I say this? The agreement, not even an agreement, one receipt with the brother of the tenant as holding.
That you have filed a suit for declaration.
Yes, Your Lordships.
Of title on account of adverse possession speaks volumes about your conduct.
Lordship, may I say this then, Your Lordship? Let me have this. Let me contest the suit, Your Lordship, because my...
Please, we are not touching the suit. The suit is not subject matter of this.
It's not a subject.
Please.
Lordships, but with regard to the title, Your Lordships?
No, very sorry.
You want to withdraw or dismiss?
Lordships, let me just...
You have filed an appeal and please raise all grounds in that.
Lordship, they cannot decide that issue is what my humble submission.
The court will pass an order on that ground.
Well, fine, Your Lordship. Only to that limited extent, Your Lordship passes, because otherwise they'll not entertain RLTOP or that is continuity appeal.
Please challenge that order. Next case, please.
Item 12. Lordship, let me withdraw it, Your Lordship.
Takes permission to withdraw. Simple.
Item 12.
Yes.
Please, Lords. Lords, it is a dispute between legal heirs of brothers and sisters.
Who are you?
I'm Milord's wife and legal heir of Shivalinga, whose favor 2 sisters.
What is your claim which you have set up?
Milord's, my claim is I'm in adverse and austere possession since 1980.
Can a co-owner be an adverse, take plea of adverse possession?
Milord's, in my favor in 1980, delinquent rights were transferred in my favor. Then
Then you can't be in adverse possession. Either you're owner. See, you're either co-owner or you're an absolute owner by virtue of your own right, but you can't take such destructive.
That is a lot more triggers.
Lords, during the life, Lords, one submission.
All 3 courts have decided against you.
Item 13.
I appear in 13.1 for accused number 4.
My lords, this is a case under section 302. What has happened, my lords, in this case?
You filed an application for...
This is an SLP against conviction, my lords.
Yes.
It's coming up for the first time. I'll just give my lords a very brief introduction to the case and the key
Is there
point.
no eyewitness to it?
My lords, there is an eyewitness as per them
who has a motive to implicate me. But be that as it may, the defense witness who we led, my lords, is admittedly the first person to inform the police about the offense. The police comes to the spot at his instance. They record his statement. He truthfully says that the deceased had a knife in his hand. There was a quarrel, and in that process, the deceased is assaulted. The eyewitness, so-called eyewitness, my lords, his statement is recorded more than 2 hours after DW1.
There are two, please kindly see, there are two eyewitnesses. Okay, let us discredit the complainant. PW5 and PW1 are there.
My lords,
The eyewitness who...
PW1 is the complainant. And so if we are to discard PW1, my lords, we are left with PW5.
Correct.
Now, even for PW5, my lords, his statement is recorded much after the defense witness. Secondly, my lords...
To impeach the credit of this witness then.
My lords, he also...
Can you see what you have cross-examined him on?
My lords, he also...
His presence is not in dispute. Having witnessed the occurrence of the incident is not...
My lords, but he has also lied about the fact that the deceased was also holding a knife. My lords will have to compare the versions of DW1 and PW5. They are both...
DW1.
My lord...
Where is DW1?
DW1 has been annexed at page 267. Annexure 12. The IO admits, my lord, that he is the person who called at 1:20 a.m. and his 161 was recorded. My lords, these two witnesses will have to be compared in terms of whose credibility is more. Further, my lords, in my learned senior's case would be different, but in my case, there is the additional fact that my name is not in the FIR anywhere. I am...
You are for accused?
Connected matter, accused number 4.
Number 4.
Sachin.
What do you have to say?
Yes. My lord, the entire evidence, my lord, in this case, my lord, has to be appreciated considering the fact it's a case of gang war. The two rival gangs, my lord, have clashed. As far as PW1 is concerned, my lord, he is already an accused, not only PW1, but the deceased himself was already an accused in respect of a case of attempt of murder of accused number 1. And they were released on bail just a month or so prior to the incident. Then your lordship will finally see, my lord, it's a case of having 3 eyewitnesses. DW1 was supposed to be examined as a prosecution witness. He was not examined as a prosecution witness. That's the reason we examined him as a DW1. Lord, he is a manager of the concerned bar who knows all the persons, my lord, the accused as well as, my lord, the witness on the deceased, because they were frequent customers in his bar. They used to come to consume liquor frequently. Lord, he categorically says that PW1 and PW5 were not present at the incident, at the spot of incident. Then there are several other aspects. Your lordship will kindly see that as far as PW1 is concerned, my lord, when he says that though he was accompanying, my lord, the deceased, when the incident occurred, he had crossed the road.
Where is your 313?
Yes, 313. In additional, no?
My lord, my 313 is at page number...
No. Yeah, PW4. He has a better case than you.
Yes.
My lords, we have the identical case.
No, you are the person who is...
My lords, if my lord is going to believe the eyewitness, we
Yes, we have to believe what is there in black and white, with due respect.
My lords,
Because they are not in front of us.
My lord,
in front of us, this black and white is there.
DW,
so we have to lie.
If I would,
due respect.
I would respectfully submit, my lords, DW1 is also present at the spot.
Doesn't mean if 10 people are present on spot and the police, only 2 witnesses have been examined, it doesn't mean that testimony of those 2 has to be ignored. It doesn't mean that.
My lord, certainly not. But then DW1's...
Even 1 witness is good enough.
But my lords, DW1's testimony should also not be ignored, and my lords will have to go into that and compare the 2 versions. My lords, this is a witness who is the first person to call the
Then
police.
who has killed him?
My lords, DW.
All right, all 5 of you have not killed him. Then who has killed him?
My lords, in fact, PW1's own.
He has stabbed himself.
My lords, if I may respect.
What is this you're talking?
PW1's own testimony is that this is a man with a large number of cases against.
He'll start stabbing himself.
And a large number of
What,
enemies, my
that
lords.
is why I want to know who he will start stabbing himself, seeing enemies in front of him. It is just not possible.
My lords, the other people have more.
Other people have stated against you.
There is a 330.
That is not on record. I will file it.
No, we are not.
And my lord, I have the hard copy. I'll just read it.
Show it. Just
Yes,
show it.
yes.
You want to see the defense you have taken?
Yes, yes. The defense is that.
My lords, other defense that I have taken is that none of the witness originally named me.
We have seen your ma'am page 265, your defense.
He says he was not there.
My lords, if I may just clarify, they say that I am a bittu. The person.
क्या हो गया? नहीं बोलते. अच्छा.
See, the moment you take that I was not present, I was at a particular place, the onus and the burden shifts on you.
My lord, I have led.
1 minute, ma'am, please.
Yes, yes.
You know.
That's true, my lord.
So what is the evidence you have led to establish this?
My lords, if I may respect.
No, please, Saras.
Questions for me.
Sir has to respond.
Yes, yes. My lord, that's right, your lordship. My lord, there is no evidence to that effect. But your lordship will kindly see himself. My lord, I am just, my lord, assailing the evidence of PW1 and PW5.
Thank you, sir.
PW1 and PW.
My lord, may please wait a moment. My lord, may hear the other. My lord, my name is not in the FIR.
Thank you, ma'am.
My lord, may just consider this. They are saying that a certain bittu.
We've heard you enough.
My lord, may I simply request? I'm requesting, my lord.
We have seen all the testimonies, ma'am. We're telling you.
My lord, may I make one request? My lord, may keep this matter tomorrow. Give me two. My lord, may consider this one argument. My lords, please. I am not named.
My lord, item 6.12, my lord. Oh, my lord.
On item 13, I think my argument is not yet complete, Your Lordship.
Okay, no, no
Yes.
problem.
Yes, I'm grateful.
What is
Lord,
See, we put it to you
yes,
that you've taken a plea of alibi.
correct.
Now, if you have taken a plea of alibi, then you know the law.
Yes.
It is for you to establish that.
Yes, my lord. Now, my argument is that even if, my lord, there is no evidence, my lord, corresponding to the defense taken, my lord, under 313, under section 165 of the Evidence Act, my lord, a duty is cast upon the concerned court.
Correct.
Yes. And, my lord, that issue has been considered by this honorable court.
No, we have, just 1 minute.
Yes.
For a moment, there is no doubt that you are innocent and the prosecution has to establish the case beyond reasonable doubt.
Correct.
We have not, I mean, on that proposition, you need not cite any law.
Yes.
What we are saying is that evaluation of the testimonies of 3 witnesses, DW1, PW1 and PW5, when we compare, we find the testimony of PW1 and 5 to be more convincing, satisfying.
Yes.
More so in view of the fact that it has been correctly appreciated by the courts below. And we do not find any perversity in that. That is one limb of the argument.
Yes.
The second limb of the argument is that now you have taken a plea of alibi.
Yes.
Were you not obliged to independently establish that alibi? Because unlike her, you have not maintained silence. She has maintained silence. You said that, no, I was at X place. Now, if you were at X place, you didn't say that I was not there. Your categorical statement is that I was at X place. If that is so, then under the Evidence Act, to establish that fact would be on whom is what we are asking ourselves.
Yes. Now, my lord, for a while, my lord, this plea of alibi, my lord, kindly ignore it for a while. Now, I am on the point of credibility of the evidence of PW1 and PW5, the so-called eyewitnesses, as against me. And it's not only as against, my lord, the petitioner who is accused number 4, but also against accused number 5, though I am not appearing for him. Because the PW1, my lord, in his evidence says that initially the attack was carried out by accused number 1, 2, 3. He says A4 and A5 came later on and joined them. So there also, my lord, this is very vital.
For what?
My lord, I came later and then assaulted. Obviously, my lord. He obviously says assaulted. So now the point is that, as my argument, I started my argument with the case that, my lord, it's a case of gang war, and, my lord, evidence, my lord, will have to be very carefully examined. Considering this angle, my lord, there will be every possibility, my lord, to involve the other person from the other gang or the other group. That's the reason, my lord, the evidence of DW is very vital. As I said, my lord, he is a manager, my lord, working in the bar. He was well acquainted with all the accused, as well as, my lord, the deceased, as well as, my lord.
We have applied our mind and sorry, sir.
So, my lord, as far as, my lord, my client is concerned, my lord, there is enough evidence. My lord, even accepting excluding this plea of alibi.
Thank you, sir.
My lord, may I apologize. Just may I say 2 things, my lords. I will not repeat. Give me 2 moments, my lords.
We will just, do you wear a watch?
I do, my lord.
Uninterrupted, your iPad would be having uninterrupted 5 minutes given to you. Please, proceed.
I am most grateful, my lords. I am not going to repeat 2 things, my lords. Firstly, the 2 eyewitnesses that my lords are convinced by PW1 and PW5. They say, my lords, they name a person called Bittu. They do not take my name. My name is Suraj Singh. My lords, it is not put to me in my charge that my name is Bittu. It is not put to me in 313 that my name is Bittu. Not a single other witness, my lord, says that Suraj Singh was also known as Bittu. For the first time in court, my lords, the witness says that he is also known as Bittu. Whether in fact, my lords, I was actually present at the offence, given the belated manner in which my name is coming up, my lords, is something that my lords would have to consider.
We have considered. What is your cross-examination on this issue?
My lords, both PW1 and the IO, I have cross-examined saying that I was not known as bit 2. I have cross-examined the IO saying nobody told the IO that my name was bit 2. My lords, imagine the witness says a bit 2 was also present. He does not give my address. He does not give any indicator to the fact that I am bit 2, and he claims to know me right from the beginning. He doesn't even say bit 2 was the pet name of the person. I have cross-examined PW1 and the IO on this point in great detail. And my lords, it is not put in my charge or in my 313 that my name is also bit 2. My lords, they have done nothing to say that the person initially named.
Point well taken. Don't repeat. You were not
Certainly.
there.
My lords, the second point, my lords had said that even if one was to discard PW1 because he has enmity, my lords, this is a point where PW5, the eyewitness, and DW2 would have to be compared. The normal parameters of seeing whether an eyewitness is credible, my lords. Did he promptly inform the police? And has he told the whole story? Now, my lords, on promptly informing the police, DW1 is better because he is the person who calls the police and says, come here, a fight has taken place, the deceased is lying dead. Has he told the whole truth? PW5, my lords, lies and says that the deceased did not have a knife with him. It is only on cross-examination and confronting him with the other documents that he is forced to admit that the deceased had a knife with him. On the other hand, the defense witness, right from the beginning, is saying the deceased had a knife. He was having a quarrel. They assaulted him. He tried to assault. They were more in number. They assaulted him and they ran away. PW5, my lords, is friends with PW1 and the deceased who have enmity with my group. DW1, on the other hand, is a neutral witness who knows everybody equally.
What does DW1 say?
My lords, he says that he knows all these people. The
Yes.
deceased was at the bar. He stepped out. Some other group came, not us. They were quarreling with the deceased and they assaulted the deceased.
Thank you.
My lords, my only request is give us an opportunity to read the evidence and compare it, my lords.
Thank you, ma'am. Thank you. Thank you.
But only one, I'm sorry, my lord, because two lawyers are, I just missed one point.
Two lawyers, we have independently.
No, my lord, I just, my lord, I want to highlight one mandatory provision. My lord, under section 157 of CRPC, whenever any FIR is registered, but it is mandatory that it should be, my lord, informed or sent to the concerned magistrate within 24 hours. This is very important. And admittedly, my lord, this has been done. That's the reason I say that.
Too late in the day. Too late in the day. Thank you.
Short adjournment.
Thank you.
Is out of.
You have to argue, please.
The arguing counsel is
have only been handed
not
to the
in
previous
city.
one. So if they have asked for an adjournment, they have apprised me yesterday that they're seeking interim minutes.
They didn't mention to the court.
They mentioned it to me, Manoj. That is why.
They didn't mention to the court. Yes, please.
No, the arguing counsel is out of city. I have no idea about this.
I will have it tomorrow, Manoj.
Tomorrow.
Okay.
Very good. Grateful.
Very good.
And he's grateful for asking.
Counsel, we'll pass over a file. You be ready. We'll give a file to you. You should have mentioned to the bench yesterday what they want to hear.
Morning, I got the from the arguing.
Don't feel him. No, call tomorrow in the morning.
Great.
May I please, your lordships? My lords, I'm appearing on behalf of Gram Principal. My twofold arguments are this, my lords. We were not in the cultivations prior to January 1950. This is what the Holdings Act clearly says, my lords. The second argument is this, my lord, that there is a judicial order, page number 31, my lords. 30th of March 1967. Please see, my lords. In this order, they themselves have moved an objection that the earlier land which was to them were not fit for cultivation. Therefore, another piece of land was given to them. So, my lords, in my humble submission is this, that publish by piece of evidence that
Yes.
well, they have to establish by way of evidence that they were in possession prior to 1950, 26 January 19, which they have not established. This is what electors have observed in this order. This is what commissioners have also observed in this.
This is exactly what the
High Court have ignored, my lord, this page 31. Please see page 31, my lords.
31.
May I read it, my lords? The second paragraph. After hearing the petitioner thoroughly, I have gone through the record, and that the only objection of the petitioner is with regard to the area of his tenancy under the Gram Panchayat. He says that the area given to him now in rectangle number 10, etc. is unfit for cultivation. He should be given some other area for the Gram Panchayat, which can be given to him. Therefore, in order
what
to
is the extent of area?
my lord,
3 canal. इतने छोटे किस लोग
they can be declared as owner, my lord. They were
no, they are not praying for any charity. They have established their right.
Please, Your Lordship. This is item 16.
Yes. Yes.
My Lord, this is a motor vehicle accident case. This is a death case wherein Your Lordship had recalled the order, wherein the SLP was dismissed.
This was in which combination?
Before Your Lordship and Justice Koteshwar Singh.
लिस्ट इसको करिएगा मैम कोटेश्वर साहब के साथ हम कब बैठे शाम को लंच कम आफ्टर लंच कम आफ्टर लंच
मेरा भी बहुत म्यूजिकल चेयर टाइप का
तो हमारे तो आफ्टर लंच आज आइटम 1
Very good.
Item 17.
My lord, in item number 17, my lord, yesterday I have received the typed copy of one annexure, my lord, filed by the respondent. Now, my lord, I need to check the veracity of this annexure from a department because they say that there is one group O. On instruction, I say there is no group O. This CGA policy was only for group C and D. No group O exists, my lord, in our department.
That's maybe in the typed copy it's come as O, but otherwise it's D only. Maybe the typed,
only.
My lords, it's D. And this document was a part of the High Court record also, my lords. And they never raised any objection to that. This was placed in the High Court.
Today may not be ready, perhaps.
But it's no, my lord, please keep it on.
List on, as per for the respondent list on coded books.
Please.
Deeply obliged. Item 18. There may be an error in the typed copy. If it is, then
there's no group O.
I'm in.
Deeply obliged.
My lord, this the High Court has considered the income on the lower side. In this, my lord.
So what about the service?
Services complete, my lord. I was appointed as a Midas.
No, did you write to them?
Yes, my lord.
Where is your affidavit that you've written?
On the last day, the respondent number 2 company appeared. They filed a counter affidavit also.
Who's for Manjeet Chawla?
Well, we have filed the counter affidavit as well.
What do you say?
Well, in this regard, my lords, they have not filed their any income. My lords, if my lords may have the paper book, my lords, they, may kindly see one that they have not adduced any evidence at trial regarding their income. MECT list of documents is on page 60. Lords, may have page 60. Not even a single whisper of how much he earned, not even his bank account statement.
What is your income? You were serving abroad, no?
Yes, my lord, but
Where is the evidence that something, not evidence, but even something to show that what is that you have?
There's a visa, if I may interrupt. There's a visa on page number.
No, visa doesn't help him, no? What was he doing there? How was he? What was he employed as? And what was any statement on record is what we are saying. Forget about documentary evidence.
my lord, we have produced the
Where is that?
ID card in which in company which he was working.
Where is that?
It is in page number
मैंने ये record आया क्या?
33.
MSCT का. What was the basis on which the High Court determined your income?
My lord, it was literally, totally on the unskilled worker. He was considered as an unskilled and he was given the order. And
order नहीं ना unskilled worker नहीं. अभी
my lord,
बाहर
ज़्यादा मिलता होगा उसका.
my lord, the lady is at 28 years.
That doesn't matter.
He was working in which country?
Dubai, my lord.
Dubai.
ज़्यादा मिलता होगा.
In 2015, what would have been his notional income there?
Well, they have not produced any application under Order 41 Rule 27 for the High Court that they have moved regarding this income certificate.
So one thing you have with your clients, any document, any.
My lord, so illiterate, the lady who has her husband, she's illiterate, my lord, she can't travel to.
No. This person must be having some bank.
My lord,
Yes. And he must be sending some money to the lady also. So if he's sending 25,000 per month, it means his income is more than 25,000 per month. So you have to do some homework. He was in Dubai, she was in India. He must be sending a month money every month.
He was recently married, my lord.
Recently married, उसको अपने parents को भेजता होगा. My lord is giving you a clue. Why don't you take it?
Find out on the family something.
Is it a referred brief?
यहाँ तो यही होगा. You're not from Telangana.
No, my lord, I am from Karnataka.
Karnataka.
What do you say, Michaels?
My lord, there's only one document on page 35 which only says that Subhash Manikappa was to be employed as a foreman in so-and-so company, but that is not signed or there's no stamp. There's also not on the official letterhead of the company.
So, but
yes, my lord.
Come to page D. Page D. From where this statement has come, the petitioner herein is the wife of the deceased Subhash. Deceased Subhash was a supervisor, foreman stores in Dubai.
Yes, my lord. My lord, his salary certificate is also on Dubai. She can't obtain it, my lord. The income certificate.
He suffered an accident before that, and certificate is pre-dated.
Established.
तभी तो उनका original record है. इसको लिखते तो अभी एक महीने में कर देते हैं.
So he must be sending money to his father.
My lord, try to produce the income. Okay.
The other thing is that you have to convert 8,000 rupees into E.
Yes,
then would it make any difference? Just see it.
Yes, but he's aiming to be earning around 3423 AED for that.
No, we are saying something else. If money earned in India is
okay. All right.
I'll come back. Giving you a clue.
Kindly give us 3 weeks time, my lord.
Calcutta record में करो digital. Record of the MSCT, also the High Court. We called for a digital copy supplied to the Land Council within 3 days. Meanwhile, we allow the petitioner to place on record any document indicating the income of the deceased from a predecessor interest of the present petitioners. That is high.
Item 19.
Hello.
I'm for the petitioner, your lord. Motor accident claims, my lord. Deceased, we are the legal heirs of the deceased person. Two grounds, my lord, I am pressing, my lord. First ground is that, my lord, he is a semi-skilled worker, rubber tapper, but his income was taken only as 10,000 rupees monthly income by the High Court.
What should it that be?
My lord?
What should that income be?
My lord, at least, my lord, 500, it is not even 500 rupees per day for a semi-skilled worker, my lord.
In 2015, what was the income of a skilled workman? What about semi-skilled?
My lord, 4,500 was for unskilled worker. It was in as per the Ramachandrappa case. In 2004, it was 4,500.
The High Court has taken 2,000.
Tribunal took it as 8,000. So when it comes to a semi-skilled worker, my lord,
took it to 10,000 is what we are saying.
yes, my lord. So when it comes to a semi-skilled worker, my lord, it must be much above than 10,000. This is my first argument, my lord.
Must be, can't be, must be. Yeah. Who's for the respondent?
No, so I'm for the insurance company.
What we can do is, Mr. Counsel for the insurer, we
My
can
lords.
give him a lump sum figure, increase by about chart के हिसाब से 30
I've also calculated.
741 हम अपने चार्ट से
May I submit my second ground, your lordship?
Yes. What is
that is, my lord? It was my appeal, and there was no cross appeal or a counter from the respondent. Even then, my lord, in several heads, the High Court reduced. Though High Court increased 1,27,000, High Court in several other grounds decreased 1 lakh rupees.
All right, doctor. We'll increase something. We'll increase.
Interest of justice.
Oblige.
We have the considered we will interest of justice be best met with the amount of compensation so determined by the courts below, further enhanced a lump sum of 50,000. Then the usual.
Oblige.
So I am appearing on behalf of the petitioner. I'll be seeking 2 weeks.
ये वो honorable justice के पास 21. अच्छा. Okay.
I will be seeking 2 weeks time for filing a short rejoinder to the counter affidavit filed by the respondent.
Lord's petitioner volunteered to pay a sum of rupees 10,000 per month to show his bona fides. However, not a paisa, not a single money has been
You kindly appreciate my learned friend has entered her appearance only on 28th January. Thrice notice has been issued from the Honorable Court.
We have filed our counter affidavit on 28th January.
Very well, no problem. A rejoinder be positively filed within 1 week.
You also kindly grant with 2 weeks time.
2 weeks. Problem 2 weeks. The amount of maintenance.
He is already married. He has breached all of his conduct.
So maintenance as ordered by the courts below be areas of towards the maintenance be positively cleared before the next date. Good revision. List.
Item 21.
Deeply obliged. Your Lordship, petitioner will have to pay maintenance.
दीजिए.
Your Lordship,
Your
Lordship, it's not true. I have not get any instruction that how she is saying, on what basis.
She's saying is maintenance, if any areas be cleared, that's what. ये वो फाइल में हुआ ठीक है
Records भी हैं ना?
हाँ पासवर्ड कर लीजिए
Item 22.
21. After lunch.
Okay. After lunch.
Deeply obliged.
22.
Lordship, I'm requesting for a small adjournment.
22 में adjournment.
Yes, Lordship.
On her request, adjourned. List on.
May I please the Lordships, my lords? The petition.
A bail.
My lords, so far as the impugned order, observation in the impugned order is concerned with regard to abscondence, my lords, I leave it to your lordships. Just two submissions I would like to make, my lords. First, my lords, though in the FIR a case of illegal trafficking has been made out, but no such provisions have been implicated in the charge sheet, my lords.
You're Mansoor, na? Your name.
But my lords, one last submission, my lords.
You want anticipatory bill after any year?
That's I completely leave to your lordships, my lords, on that point.
No, please. No, if you agree with me, then be happy.
I appeal for the state on advance service.
Yes.
Your presence will be marked.
Lords, liberty may be given to move for regular.
Who is stopping you?
When will you surrender? Okay.
As your lordship says, my lords.
Undertakes to surrender on or before एक हफ्ते का time दे दीजिएगा. As and when the petitions, with the petitioner surrendering, it shall be open for him to move an application seeking bail, which shall be decided in accordance with law.
Obliged to lordships.
Undertaking accepted and taken on record कर दीजिए.
Obliged to lordships.
In 1 week surrender.
Item 23.
23.
23
ये तो हो गया.
23, I just appeared in this matter.
24.
24, I am appearing through VC, my lord, due to some bad throat.
Item 24, who's there?
I am appearing, my lord. In item 24, I am appearing.
We are issuing notice.
Lordship, please. Lordship, I kindly condone the delays. Legal aid matter, my lord.
No problem. Delays condone. मैम एक काम करिए. वो सरकारी वकील साहब की हाजिरी लगा लीजिए. Name to be reflected. Reply 2 weeks. Adjourned 1 week. और जो हमने कल ऑर्डर किया ना, एक रजिस्ट्रार साहब से रिपोर्ट मंगवाई है.
इसी में कर देना. इसमें भी कर देना.
इसमें भी कर देना.
Obliged, my lord.
Item 25.
Lords, in item 25, your lordships had asked me to prepare the report, my lords, of the amicus. I'm handing it over because the portal would not accept it, my lords, as a filed document.
अभी मसीह साहब के साथ सुन.
हाँ ठीक. ये
2:15 बजे.
ठीक.
पोस्ट लंच.
Sorry, post lunch. 2:15 बजे आदत हो गई है.
2 o'clock. That's because of High Court.
Because in the High Court it was 3:15.
Yeah, High Court.
2:15. Deep levels.
26.
My lord, 26 page 81 shows that, my lord, the matter had been referred to mediation where it had been settled.
Mediation is paid now.
No, my lord, mediation had been conducted, my lord, page 81 may kindly be seen. It had been already referred to mediation and where the matter had been settled also. Kindly see page 81 of the paper book. 81, 82.
Disposed of in terms of the settlement.
Yes, my lord, yes.
No, you say you don't press in terms of the...
Lord, that this information has never been conveyed to me by the party or the
That's all right. We'll say does not press the present petition in view of the report of the learned mediator as forwarded with a communication dated 10/10/2019 that of the Director, Kerala State Mediation and Conciliation Center. That's it.
Grateful, my lord.
Item 27.
My handicap today, my lord, is that the High Court on the first day dismissed the petition, but order is not available. And my lord, for almost 2.5 years, or maybe 2 years and 3 months, there was status quo order operating in my favor. The builder, my lord, wants to extend his building, and for that, whatever shop, whatever halfway, my lord, was available, that also wants to be demolished.
Your own case is that you are not in possession.
No, my lord, that's not.
No, your own case is that they've demolished. You have put up a tin shed there now.
Which is existing. Please have a look at, my lord. Please have a look at, my lord, the order passed by the appeal court at the interim stage. Page 37.
It must have been uploaded by now on the website.
No, it is not. Lord, 2nd of March it was passed. And my lord, the High Court rules require that you have to issue rule, make it returnable, so that, my lord, I can file my reply. My lord, whatever, my lord, may be reasons against me,
Notice here is status quo has been.
I'm so obliged.
It's 28 4 co-accused have been already granted bail, my lords.
It has to be tagged.
Yeah, my lords, interim to me also, protection from arrest. This is an anticipatory bail.
Same order over there. Or tag kar dijiye.
Others have been granted. We will also.
Yes, sir. My lords, the others are coming on 9th February, my lords, after notice. So this may also be listed on 9th February.
You accept notice? Yes. वो कर दीजिएगा. So same order. With the same condition subject to joining if
Obviously. Yes. Great.
Please, Milord. Because here the wife moved an application, Milord, on the ground. Milord, in the divorce proceeding, Milord, the husband moved an application that enjoined the wife from coming near to me because I am carrying out a 70 crore project. And on that basis, Milord, the trial court says...
No, it is that you will not enter the matrimonial house.
Yes, Milord, look at the plea. Yes, Milord, the pleading. Yes, Milord. So in every which way, Milord, kindly see, Milord, what has been recorded.
We tried mediation, it didn't work.
Yes,
you know, you have a right to, residences on a matrimonial.
Yes, Milord, that's right, under the DV Act.
One minute,
yes,
1 minute. But under what circumstances? What circumstances?
Milord, when I am in the sharehold, living with the husband.
Better both of you sit and sort it out again. Mediation.
Because we have tried, Milord.
Tried multiple.
I'm ready to go back, Milord. He is not ready to accept.
They interacted with the parties, my lords. Thereafter, Mr. Basant also had tried.
Oh, Mr. Basant.
Also tried, my lords. We had made multiple attempts, my lords. The wife is adamant she wants to live with me, my lords. My move.
That you give up. That insistence that you want to live there only, give up. Or some alternate accommodation will be provided for you.
Let him provide alternate accommodation.
Lords, she's living in Banjara Hills with her parents.
We are only saying
Banjara Hills.
And my lords, with her parents, my lords, since August 23, we have not lived together.
If you are living in Banjara Hills.
Both of them, Milord, both of them come from a well of. Yes, Milord. Now, therefore, Milord, my only concern.
I also stayed there for 2 years. They're not known to me. No.
I didn't see that coming.
But Banjara Hills, she doesn't need any accommodation if she's having.
Yes, Milord. Now, therefore.
Very well people live there.
That's in fact, she's not even moved a 125 application, my lord, despite multiple proceedings. So both of them are reasonably well off, my lords. That I think is an admitted fact, my lords. It's an interlocutory order, my lords. Let the divorce and the restitution petitions be disposed of in accordance with law, my lords. That's all my request is. Because your lordships has noted the parents. I live with my parents, my lords. They have issues, my lords. There's an FIR charge sheet under 498 against my parents and my extended family. There's no possibility for us to live together, my lords. With greatest respect.
Mediation has failed.
Mediation multiple times, lords, before this honorable court, the mediator, the Supreme Court mediation center. Your lordship has also interacted with the parties.
Plus, may have it after 2 weeks. Plus, I'll again speak.
Put it to her.
Yes.
Put all issues
to
an end on his authority. But we are telling you what is going to be the outcome.
Please.
Obliged.
Passover 6.
Obliged.
My lords.
Yes.
My lords, why the additional charge should not be raised? There are two aspects of it, my lords. That is, first is that wrong charge has been framed. It is not due to hurt or assault, but it was because of the heart attack. And kindly see page 45, my lord. It is very specific.
We are not driving you to charge has been framed to be proven by the prosecution. That's about all.
But that is the initial charge, my lord. That is after the final hearing. 1 month has been passed and judgment, it was fixed for the final judgment. And
so therefore, if the court feels that charge was required to be framed.
Exactly. I'm not denying that, my lord. What I'm saying, kindly see 45, my lord. It will be all clear, my lord. Why it is not even there are two aspects, my lord. That is not a hurt also. Kindly see para 21. It is true that as per the histopathology report, PW 49, the disease was already suffering from heart disease and illness of the heart artery previously. It is true that the heart of the disease was excessively weak due to such defect, and there was every possibility that he may suffer the heart attack anytime.
So this
It is, my lord, just 22, my lord. It is true that disease Vikas Sharma was not died due to any assault or hurt, but it was due to heart attack. The witness stated on his own that it was due to excitement. When it was asked to the witness whether excitement can be caused without any dispute, then the witness stated that there are several reasons for excitement. I am saying that 333 is for grievous hurt, and there is no cause of hurt or assault that has been. And kindly see page, because this honorable court has granted the bail, and while granting the bail, 42, page number 42, my lord. However, para number 3, page number 42. However, taking into consideration the expert medical witness.
Thank you.
My lords.
Yes, my lord.
My lords, but he was not on duty also.
Thank you.
Not he was hurt also, not even he is on duty.
Thank you. Yes, have you taken
May I please? I have.
Much over.
My lords, I have, my lords. My lords, as per the charge sheet, my lords, I have to repay about 30 lakhs, my lords. As per my account, it is coming to 33 or 34 lakhs.
30 in which year?
In 2001. So I spoke to my client, my lords. Then whatever lordships, whatever terms and conditions lordships
You tell us what we will deposit.
the interest from 2001 or whatever.
We do not know.
Initially, we'll deposit that amount, my lords, and whatever the interest or anything.
No, you do one thing, you deposit 2 crore rupees.
My lords.
And also your title deeds.
My lords.
Simple. And then we'll call them.
My lords. For 2 crores, my lords, I need 1 week to understand, my lords.
With people.
Let the petitioner deposit. Council under instruction submits the petitioner shall deposit a sum of rupees 2 crores in the registry of this court. The amount be kept in fixed deposit or renewal mode. Let needful be done within a period of how much time?
Well, they need about 4 months.
4 months.
Because 2 crores are not interest with interest. What
in installments spread over a period of 3 months. The first installment to be paid within 3 installments are tranches. First to be paid within to be deposited within 2 weeks. Then also petitioner shall deposit the title deeds. The title deeds of which land? Land, which land?
Well, as the schemes as mentioned in the charge sheet.
Which title deeds of the
schemes mentioned in the charge sheet.
Of the area forming part of the scheme, subject matter of the FI.
Yes.
The title deed, the documents of title be deposited in the registry within a period of 1 week from today.
My lords, make it 15 days, please.
No problem. 2 weeks from today. ये लिख दीजिएगा. Council under instruction further submits that the land is unencumbered and is in possession of the petitioner. Correct?
My lords, it's in the possession of the parties. I cannot say. It's already in their possession.
Unencumbered, yes. Unencumbered, no? Has clear title and is unencumbered. Clear title in the petitioner's name. List on dash. Now
the interim protection may continue.
Interim to continue to the next date.
Great.
2 minutes रुक जाइए.
Great.
What we'll do is, can you do one thing? A different combination is there. You are here, Mr. Bharat. 2 o'clock. Thank you.
My lord, may I mention 102, my lord?
Post lunch. Sorry, my apologies.
To be taken. Three passwords.
Yeah. थोड़ी देर बाद ही एक वो ब्रिटिश मोटर वाला जो है वो हम डेट जिस दिन साहब के साथ बैठे हैं ऐसा करिए
No, before lordship starts his own mail, trouble your lordship for item
बोल दिए
104.
ब्रिटिश मोटर वाला आपके देखते ही बोल दिए ब्रिटिश मोटर वाला साहब के साथ बैठेंगे
Lordship has said 17th.
17 को बैठ रहे हैं कि साहब के साथ You have merged into that company or
No, we have not merged. The banks have merged. It's a private merger.
कर दीजिए ना सर कर दें पार्ट
जैसे भी आप लॉर्डशिप में अभी डेट
करना छोड़ देते
up to you entirely.
सर आपके पास है
आपके पास whatever convenient. मैं तो हूँ. Lordship, maybe at 2 p.m. get over.
Time we will have.
I'll leave it to your lordship. Convenience.
I think it, but it is covered against you.
That's what lordship every time tells me.
He
But
scare you.
no, but because we have points to distinguish.
Okay, very well.
My lords has indicated.
The lordship is making 17th February. Deeply obliged, Lord.
My lords, you indicated item 16. That's a motor vehicle accident case to be taken up before the special bench.
8 minutes.
The order was recalled. It was passed by a.
वो सैमसंग हम इसको रख लीजिएगा सबके साथ ही है हाँ
पार्ट हेड करके करते हैं
पार्टनर नहीं करिएगा ना जिस दिन आप
ना बेंच का प्रॉब्लम होता है तो वो खाली वही मैटर लेते हैं जो पार्ट हेड है
कर दीजिए एक और है ये 21 वाला कर लिया डेट बता देंगे ना इसमें तो हर रोज ही बैठ रहे हैं उस दिन एक करके ले लेंगे ये जो आइटम 21 है और जो 16 है तो एक करके ले लेंगे
और 25 रहेगा बस अपन
Chief, that amicus is also here, man. So the report has been asked to be placed on 25. Both of us are here.
It has to be allowed.
Because I'm in the middle because I didn't get space, my lords, on the other side.
No.
I just wanted to place 1 point, my lord, for your
We'll
lordship.
do what we'll do now. Today we'll not take it up. Same combination is likely to be there on Monday also for some time. So then we'll take it that day.
This 1 point, my lords, I'll place for your lordships and I'll leave it to your lordships.
You're a amicus, no?
Yes, sir.
You've written to her.
Written, my lords. The entire report, my lords, is before your lordships.
But to our understanding, that matter where 90,000 was paid or some.
9,30,000, 30,000.
Was left.
30,000.
It has to be allowed. No.
That's what my lords is saying, my lords. Just 1 point and I'll leave it after that.
What is the point?
My lords, on the issue of readiness and willingness, it has been held concurrently against them.
You know that.
By the first appellate court as well as before your
As
lords.
against the consideration of 9,30,000, if only 30,000 in the balance consideration,
My lords,
then we say readiness and willingness.
Lords, the agreement gave them an option to pay within 4 months or to deposit it in court.
This time was the time, the sense of the contract. Look into that.
I'll look into it.
So, we are indicating you.
Yes, my lords, of course. We'll be done.
Monday, mal.
My lords, in item 16, that Samson V matter.
We have told you, sir, we'll take it up. We've told you, some date will be there.
Obliged.
Start.
With my lord's permission, just before my learned senior staff, the lordships are appearing, we filed the final report in this matter. There's just one small request.
Which case?
The lordship's item number 301.
Charge sheet. Wait, what is the final report? Justice Committee?
Yes.
This is it.
Independent Committee
Justice
final report in item number 301. Your lordship, we have filed that. There is one small request from the committee that an honorarium may be fixed for the.
We are conscious of that.
Your lordship, it may be mentioned in the order that a specific fixed honorarium may be provided
We
to
are
engineers.
we are conscious of that fact. We are deliberately not touching that aspect. We are deliberately not touching that aspect. We'll do that.
But this side there are several counts.
So whichever way.
I have a special bench blood, so I'll just finish that and then.
No problem, we've told you that none would be having,
I'm
none
grateful.
would have any grievance, they will not hurt.
I'm grateful.
The, thoda kagaz de do. Yes, start please.
Lord, I appear, my lord.
मैम ट्यूसडे का क्या स्टेटस है? ट्यूसडे को किसके साथ हैं? आप किसके साथ हैं सर?
Yes, my lord. But I appear for some of the allottees, my lord. And there is a miscellaneous application filed for cancellation, which I'll be referring to, my lord. And I'll give the number also. I've already given to the court master the files which I will be referring to. But before I do that, my lord, may I request your lordship to have the proceedings of this court in the writ petition. Starting with, my lord, the first order by which bail was granted to Satinder Bhasin. Now, that is an order passed, my lord, on 6th of November 2019. So, if you can hand over the proceedings of the court in writ petition criminal 242, which contains all the order sheets, proceedings of this court, the orders passed from time to time. I'm starting from 6th November 2019.
तो बोर्ड तो डिस्चार्ज कर दीजिए। मैम बोर्ड डिस्चार्ज कर दीजिए।
Then what do we do? They don't have the order sheet.
Cancellation of bail application will have it available. We have to consider
proceeding
There must be most fundamental.
You want us to refer to the bail order?
That's 6th November is the bail order. And then there are other orders passed, my lord, in the said writ petition, which I want to refer to, my lord, pertaining to settlement issue, my lord. Because since I'm appearing for the allottees, my lord, I want to highlight that particular fact. But first, my lord, please have the order of 6th November. I believe, my lord, now your lordship have those orders, my lord, in this file. 6th November 2019 order, my lord. Just 2 paragraphs, my lord, and then the operative direction by which bail was granted. Your lordship has that 6th November order?
6th November?
6th November 2019. That's the order granting bail, subject to certain conditions.
To some other orders in the said writ petition, which talk of settlement, etc.
Yes.
Your lordship has that order, my lord, 6th November 2019.
By this order we propose.
That's correct, my lord, that's correct. Please turn to, my lord, paragraph 4. My lord, your lordship, Justice Singh also has that.
Yes, I will.
Correct, my lord. Just come to first paragraph 4, my lord. There is a reference to large number of FIRs which have been lost. Just have a look at that, my lord. There are several FIRs, I won't read that. Just make a note of that, my lord. The lordship sees that, paragraph 4. Several FIRs. Now come to paragraph 7, which refers to the allegation in these FIRs, my lord, filed by the unit holders or the allottees. It is also.
How many FIRs? 18 or 19?
190.
No. Number of FIRs against him.
100 against Satinder Bhasin. 190. 190. It has come on record, my lord. In the other matter,
because para 4 reflects only about 90.
That's right. But there is another order which refers to some more FIRs.
190.
Yeah. Para 7, my lord. It is also noticed, your lordship has that. Para 7. It is also noticed from the allegations in all the separate FIRs filed before the concerned police stations. Same are virtually similar, if not identical or stereotyped, and essentially making grievance about non-delivery of possession of units to the concerned complainant allottees, including the assured lease rental assured returns in respect of the concerned units. The other common aspects in the separate FIRs is about non-completion of the project as assured and about siphoning of funds. Please make a note of that, my lord. About non-completion, non-allotment, not giving rentals assured returns, and siphoning of funds raised from the completion of the project in question. The allegations is also about legality or impropriety in allotment of land to the company by the officials of UPSIDC. The latter allegations, however, is common only in the FIRs registered in the state of UP. Notably, the investigation of FIRs registered so has been entrusted to a special investigation team constituted by state of UP. To that extent, all the 37 FIRs registered are being investigated by one agency, and that agency is filed charge sheet. So I just wanted to show your lordship what are the nature of allegations in the FIR. Now your lordship may straight away come to the bail or the operative order in para 16, my lord. Para 16. May I read, my lord, para 16? In view of the above, we dispose of the prayers for interim relief in terms of prayer clause C and D of the writ petition on the following basis. The petitioner is granted bail in respect of all the FIRs registered in prayer clause C in respect of the project by name Grand Venice in NCR, in particular, mall and commercial tower thereof, on the following conditions. Please mark that. I'm so sorry, my lord. My lord, Roman 1, please make a note. Petitioner shall not commit any offense of similar type of which he has been accused. And siphoning is one of that, the allegations in the FIR. Your lordship have seen that one. So shall not commit any offense of similar type. Then, my lord, if your lordship turns over to also, my lord, the petitioner shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the facts of the case so as to denude such person from disclosing such facts to any police station or tamper with the evidence. Because, my lord, there is something on this also. We'll point that out. Then, my lord, I'll just skip and come to Romans 6. Romans 6, my lord. The petitioner shall deposit an aggregate amount of 50 crores before the registry of this court as a precondition for grant of bail. On deposit, so petitioner shall deposit, my lord, on deposit of such amount, authenticate copy of the receipt issued by this court be produced before the concerned court investigating officer. The amount so deposited by the petitioner in the registry be invested in an appropriate account. Then, my lord, Roman 8 is very important from the allottee's point of view, my lord. Just have a look at that. After being released on bail, in terms of the order, petitioner shall make every possible attempt to settle. Because this was also highlighted by my friend that the condition was attempt to settle. And I made bona fide efforts to settle. That's the, my lord, submission of my learned friend, my lord. To settle the claims of the concerned complainant informants as far as possible within 6 to 8 months. So within 6 to 8 months, the time period is also mentioned by the court, as ordered by the Court of Chief Judicial Magistrate while granting bail to the petitioner in FIR 38 registered with the economic offences wing. So that is one of the FIRs, my lord. Roman 9, if the petitioner fails to abide by any one of the above conditions intentionally, and if it is so established before this court, no less than 50% of the amount deposited by him in this court in terms of the order shall stand forfeited.
There will be an addition to cancellation.
So, my lord, this also, my lord, I believe, my lord, in one of the earlier hearings, Mr. Devan said the only consequence provided is 50% of the amount deposited shall be forfeited. My lord, I don't think that's a correct reading and a submission made by my learned friend. Assuming, my lord, we are able to establish siphoning or tampering with the evidence, then, my lord, Roman 9 can be read. If I'm not able to establish, a different matter, my lord. But if we are on this side able to establish that this has happened, then, my lord, to say that the consequence is limited to 50% of the 50 crores amount may not be correct reading of the order. This is in addition to cancellation. Now, my lord, let me take your lordships to another order of 8th August 2023. August order, my lord. My learned friend's client wanted a refund of that 50 crores. While rejecting that, my lord, 8th of August 2023. While rejecting that, my lord, request for refund of the 50 crores, which the court rejected outright. In fact, the court said, if you want the money back, surrender. That's what this court said, my lord. That's 8th of August 2023. Paras 11 and 12, my lord.
1 minute.
I'm so sorry. I know, my lord, there are large number of orders in this matter, my lord.
No difficulty.
Yeah.
Everything is.
In the same.
Sorry, senior.
Lord, 240, writ petition 242, my lord.
242.
Yes, my lord. 8th August 23 order.
Yeah.
My lord, your lordship will find para 11.
Just 1 minute, sir. Honorable Justice Oka.
Yes, my lord. Yes. That's correct.
8th of August.
Yes. Order sheets.
But not a separate one.
Order sheets they have not compiled with separate.
8 August.
My lord, perhaps I should have done it, my lord. It's my fault.
There's so many on non-relevant orders also.
I know, my lord, there are quite a few, my lord.
Really eligible.
8 August?
Huh?
Sorry, eligible.
Do it, whatever you want. My lord, can we help your lordship by giving a soft copy or something?
My lord has it, but just.
But again, my soft copy was unable to get it. 8 August.
May I do this, my lord? May I just read?
8 August 2023.
8th August 2023. Then take out 2nd September and 24th January. 2nd September 2024
Get it.
and 24th January 25.
Mr. Mehta.
Yes.
8th of August, then
8th of August 23. Then after that, I want to read 2nd of September 2024. Then I want to read 24th January 25. These are the orders I want to read now.
and 1 minute. One more order whereby the writ petition was disposed of. Which is that order?
That's the 8th.
No, writ petition was disposed of, the consolidation order. That was on 12th of May 2020.
The writ petition was disposed of.
Not disposed of.
No, it's,
writ
it's
petition is
pending application. No, not the, yeah, 8th August 23. 8th August 23. The writ petition is also disposed of on the above terms. So, about 242 came to be disposed of by 8th August 23 order. Then subsequently applications came to be filed and the further orders are allowed on the applications. And those orders will require, which I've just mentioned, 2nd September 24 and 24 January 24.
It is disposed on the aforesaid terms.
Yes, well, your lordship has that, Manu? Just give it to those orders, two orders, 2nd September 24 and then 24 January 25.
सॉफ्ट कॉपी में नहीं है अभी देखना पड़ेगा
हमें देखिए
Eight August 2024.
23, sir. 8th August 23. Honorable Justice Oak is heading the bench.
जो सॉफ्ट कॉपी है इसमें नहीं
No problem, sir. ये लीजिएगा. अच्छा. कॉपी है क्या? लीजिएगा.
ये ऑफिशियल इसमें भी नहीं है.
But I apologize for this inconvenience, fellow. 8th August is available now. Lord, your lordship will find in the 8th August order by which writ petition is disposed of, a prayer was made for refund of money. In para 11, your lordship will find that. Para 11 of that order. Now the issue which survives for consideration about the prayer for refund. Now, my lord, the court cites, my lord, or extracts that part of the order, 6 November, then para 12. Thus, deposit of a sum of 50 crores was a condition for grant of bail. Therefore, it is obvious, after having availed the benefit of bail, now the petitioner cannot back out and say he may be permitted to withdraw a sum of 50 crores, which was deposited by him as a condition for grant of bail. If the petitioner wants refund, he'll have to surrender, but the petitioner cannot have it both ways. So, my lord, just see, my lord, he first, my lord, there's a condition of bail. Say, I'll comply with the condition. Once, my lord, he gets bail, he now says that I will want to withdraw. Para 14, we reject the prayer made by the petitioner for a grant of refund of sum of 50 crores and interest thereon. My lord, the allottees wanted distribution of that amount, my lord. My lord, if your lordship sees, in these proceedings, we cannot decide the issue of distribution of any of the sum of 50 crores. The fourth respondent represents only 70 investors, and whether 17 members of the fourth respondent entitled to a refund is an issue which will require evidence. We are unable to accede to the request made by the learned senior counsel appearing for R4, but that amount be paid over to, not because the reason is obvious, my lord. My lord, the request was made because this was our money, which was used for deposit. Now see para 20, my lord. Para 20, 20. Because we said, my lord, that the bail should be cancelled. So para 20, the court gives me this liberty to all the allottees. Your lordship has paid para 20, it will be open for R4 or any other party to apply for cancellation of bail granted to the petitioner under the order dated 6 November 19. If such an application is made, registry shall accept and place it before the appropriate bench. So that liberty was granted. Writ petition, my lord, para 22 is disposed of on the above terms. Para 22. Now, my lord, come to 2nd September order, my lord, 22nd September 2024.
Stick-ons दीजिए.
My lord, I'm sorry. 13th May 24, my lord. My mistake. 13th May 24 first, before we go to 2nd September. There's another order, 13th May 24. That's also important, my lord. 13th May 2024. May 24 you have given. Yes. The lordships have been able to locate the order, my lord. 13th May 2024. My lord Justice Karwal also has been able to locate it.
Kali, I'll be doing that. You may pursue, please.
My lord, this is important, my lord. Just have a look at what the court says, my lord. We have perused the supplementary reply. We have perused the supplementary reply filed on behalf of the petitioner. We are not satisfied with the stand taken by the petitioner that he has made genuine effort to settle the dispute with all the investors. In fact, from the order of 6 November 19 granting bail, it is apparent, please make a note, it is apparent that the object of releasing the petitioner on bail was to facilitate settlement of the claims of the investors. This is the court saying, my lord, not we. That was the purpose, that you will go and settle with these investors. That's the object, which is recognized and acknowledged by the court. That you will go and settle, not make bona fide and sincere efforts. I'll come to the bona fide part later. Firstly, we will call upon the petitioner to file a detailed affidavit setting out the reasons why petitioner could not settle the claims of 41 investors named in the status report filed by the respondent 2 on 8th of May 24. We grant time till the end of June 2024 to the petitioner to do so. After looking at the details submitted by the petitioner, if we are satisfied, please note, if we are satisfied, all efforts have been made by the petitioner to settle the claims with these 41 investors. We will look into the claims of other persons as well. More than 4 years, my lord, please make a note. More than 4 years have elapsed from the date of grant of bail. So, my lord, the court is noticing the time period which has elapsed because 8 months was given. We are putting the petitioner to notice. If we find there is no genuine or bona fide effort made by the petitioner to settle the claim of even one investor, that may be a ground for cancellation of bail. Just see how strongly the court is putting it, my lord. So to say that the court only wanted me to make bona fide effort, Lord, is that correct? You were released so that you could settle with the investors. Lord, please note, 2010-11, all these investors have paid 80 to 100%, my lord, of the installment money, my lord, to the builder, to the developer. 14, 15 years down the line, we have not seen, my lord, these units completed or and possession handed over. So, my lord, if we find that there is no genuine or bona fide effort made by the petitioner to settle the claim of even one investor, that might be a ground for cancellation. So, my lord, to say that bona fide and sincere effort, that's not what the court thinks, my lord. The court's understanding of its own order is very clear. That's the point I'm making, my lord. Come to 2nd September, my lord. 2nd September 2024.
And
2nd September 2024.
please read.
Yes, my lord. Now the issue is, sorry, my lord. Now the issue is whether original writ petitioner has set. Yeah. This is 2nd September.
Yes, please.
Now the issue is whether the original writ petitioner has settled the dispute with 103 investors, not bona fide effort. Have you settled? For the time being, we are dealing with cases of 41 investors who are referred to in para 28 of the rejoinder, filed by the petitioner to the response of the state, dated 23rd August 24. We direct the petitioner to implead these 41 persons as party respondent, file an amended copy within a period of 1 week, issue notice, registry to forward the notices to the office of so and so. The 41 persons shall come.
Then what happened?
Yes.
After this?
That now I want to read one last order, my lord, 24th of January 25. Because, my lord, several orders have been passed from time to time. I'm only bringing to your lordship's notice, my lord, few of them. Please come to 24th January 25. So we have reached 25 now, my lord. And that order was passed in 2019. No settlement. 24th January 2025.
In your submissions, you don't say all this. You see the difficulty which...
My lord, I will show that, my lord, because perhaps your lordship saw the recent application.
Submissions.
I see, submissions.
See, the submissions, the purpose of submissions is only this, that we must know what is that you're going to argue.
I apologize, my lord. I'm going by the record only, my lord.
And therefore, day before yesterday.
No, I know.
Yesterday we told you.
Lord, I understand.
In your submissions, there is nothing which is mentioned except for bold,
No, I appreciate, my lord. I appreciate. Lord, your lordship has the order now, my lord, 24th January 2025.
Yes.
We have perused the affidavit of compliance. He was asked to, my lord, file an affidavit of... I'm so sorry.
Please read.
We have perused the affidavit of compliance along with the tabular chart filed by the state. The tabular chart is only in respect of 43 investors. Chart shows still the petitioner has not settled with many. Time and again, this court has granted time to the petitioner with the hope that he will settle the claims of all the purchasers. Settle the claims, not effort. A perusal of the orders passed by this court from time to time will show, only by way of indulgence, please note, only by way of indulgence, this court has kept on postponing the consideration of prayer for cancellation of bail. The court has granted indulgence to him. Now it is not possible. Now it is not possible for the court to grant further time. If in one of the orders we made it very clear, unless the claim of every investor is settled, petitioner cannot continue to avail of the facility of bail.
Then what happened after this?
Lord, after that, my lord, the adjournments, my lord, because the court did not have time, my lord, and there is no substantial order till such time, my lord, your lordship took up the matter, my lord's order of November. My lord, your lordships have seen this. Third paragraph is, however, by way of indulgence, you have to file an affidavit, you have settled. So, my lord, then your lordship's last order of, sorry, did. What is that?
This was in January 25.
January 25 is another order, my lord. Where is January 25? No, I'm also having...
That's what you read out.
No, I read out 24th January, my lord.
Yes.
Correct. Your lordships have seen that, my lord. How strongly the court has put it, my lord. Then, my lord, is your lordship's order, after noticing the entire proceedings, etc., issuing show cause notice to him as to why the bail should not be cancelled. That your lordship's order is of 20th of November 2025.
Just
After which,
one, मैम आप एक काम करिएगा, ये minus
I will do that, my lord. I know, I've seen, my lord. I'll put it in a bunch, my lord, and with an index. I'll give an index and.
No, only without the.
No, not the relevant, all audits.
Only date,
All order.
date and order.
Without the appearances.
Without the appearance. And the bench combination.
And the bench combination. The first page and the relevant term. The first page will have the bench combination.
Prepare an index in a tabular form Excel sheet, the date of the order, the bench composition,
all right,
and the extract, not the extract, but the orders.
Gotcha.
Just a compilation.
We'll do that, my lord. We'll do that today itself. We'll do it, my lord. My lord, two more orders, 22nd April 25. 22nd April 2025. I know the appearances, my lord. 3-4 pages are taken because there are a large number of lawyers. My lord, the affected parties, my lord, there's so many allottees, my lord. Or waiting, my lord, for 15 years. Yeah. 22nd April 2024.
Yes.
25. The Lordship has it?
Yes.
The learned senior counsel appearing for the petitioner seeks time, that's Mr. Divan, though more than sufficient time has been granted to enable the petitioner to comply with the condition on which he was enlarged on bail. Only by way of indulgence, we are granting time till next Tuesday, 29th April 25. This is how, my lord, strongly the court was, my lord, the court was very upset because despite, my lord, getting bail on the condition that he will settle with all the investors, my lord, 5 years down the line, nothing, my lord, had happened. And I will show, my lord, my learned friend's averment and assertion that, my lord, he settled with 53. My lord, they are only paper settlement mediation agreements. I will show that because he has not complied with them. So he enters into these settlement agreements and he doesn't comply with them.
Those parties with whom we had entered into settlement, are they before us?
I'm appearing for them. I will show from my application, I filed those settlement agreements. I filed those settlement agreements to show this is what he promised me and he doesn't fulfill that promise.
We'll have, this is note down. If you will stand up, then everyone will stand up. We'll give you time, we've told you.
So, my lord, I'm appearing for some of them, my lord. My friend also appears for other allottees, my lord. We filed the settlement, my lord. He says, I will do this. And then we sign it.
Now show that.
Yes, I'll show that. My lord, just one more order, 29th of April. 29th April 2025. So court wanted to see that the project is, court was trying to ensure, my lord, that the investors and the unit holders get possession of the property. April, may I read, my lord?
Yes.
Firstly, we'll deal with the issue of settlement entered into by the original petitioner with 41 buyers of the units whose names appear in Annexure 820 to the affidavit. It is claimed in the affidavit, possession of 23 units has been handed over to the persons mentioned in Annexure 820. It is stated 10 purchasers whose names appear so and so have shown unwillingness to take possession apprehending that registration of the document will not take place, we direct UPS IDC to immediately nominate 3 senior officers to visit the building in which the units mentioned in Section 820 are situated. Officers will visit the site when a representative of the petitioner shall remain present along with all documents such as occupation, CC agreements, if any, entered into with 41%. Representative of the petitioner will also bring the document showing delivery of possession as regards these 41 units, excluding the units to be allotted to 8 persons who have already taken refund. The officers of the authority shall verify the documents produced by the petitioner and submit a report to this court on the following aspects: whether the units mentioned at serial 1 to 23 and units mentioned at serial 1 to 10 are in habitable condition. Because, my lord, there are 7 reports which are available on record, my lord, that they are not at all habitable. Whether there is electricity and water supply available to these tenements, whether there is occupation completion certificate with respect to these 33 units. My lord, now that the judgment in the other matter has given findings on this, finding that they are incomplete, there is no final CC, and my lord, they are completely, my lord, not habitable. That all those findings, and my lord, the court also record that settlements have not been complied with. I will show that also. From the judgment in IBC matter, that findings have come now against that. My friend should have read it, my lord. Whether there is an occupation CC, whether possession of these units has been handed over, my lord, if it was only a bona fide effort, why was this court so concerned time and again trying to ensure that these unit holders get possession of the property? Then they should have left it at that. We have already passed the order. Now to make efforts. Is that so? No, my lord. The court's intent and object was very clear. We are granting you bail so that you hand over completed units to the investors.